We've got a quorum present. So Karen, oh, great. Thanks. We've got the live stream going. So good morning, everybody. Welcome to the Committee on Veterans and Legal Affairs. We're assembled electronically this morning and for today to work on a number of bills, which we've heard and are before us for work sessions. So before we get started, we'll begin with committee introductions, starting with Representative Chiazzo.
Thank you, Mr. Chair. Good morning, everybody. Happy Friday. Representative Chris Chiazzo, House District 28, beautiful, temperate, mild, sunny, happy West Scarborough, Maine.
Representative Wood.
Good morning. I'm Barb Wood, and I represent District 38, the western end of the peninsula in Portland.
Representative Corey.
I never get to go this early. My name is Patrick Corey. I represent House District 25, which is part of Wyndham, obviously caught off by surprise this morning. But thank you. Thanks for coming out.
I just follow the boxes wherever they assemble on my screen. Senator Hickman.
Good morning. I'm Senator Craig Hickman, representing 11 towns in southern Kennebec County, including beautiful Winthrop in the Winthrop Lakes region. And I just want to say welcome to Memorial Day weekend, where we honor our heroes, but it's also the first weekend of summer. So there you go.
Representative Riley.
I am Representative Riley. I represent House District 34, which is part of Westbrook.
Representative McCrate.
Good morning. I'm Jay McCrate, representing Harpswell, West Bath, and Northeast Brunswick. In the House.
Representative Supika.
Good morning. I'm Laura Supika, and I represent House District 126, which is a portion of Bangor.
Okay, and my name is Louis Lucchini. I represent most of Hancock County in the Senate. With us today, we have our committee analyst, Janet Stocco, and our committee clerk, Karen Montel. And so we've got the day kind of broken up into topics. We're going to be bouncing around a lot and just kind of cleaning up leftover bills. So obviously at any time, if people want to break and caucus or take time to slow things down and just take a look at what we're switching around to, just let us know and we can do that, because we are bouncing across all topics that our committee deals with. So, but in this 10 o'clock block, we have two bills, LD 916 and LD 1726. Then just so people know, at 11, it looks like we go to sports betting, 12 liquor, 12:30 tribal gaming, and then 2 o'clock the marijuana bills. So just to give everybody an idea of where we are. So I guess let's, if we can we start with LD 916, Janet, please?
Sorry, I had the other one open, just switching.
Sorry.
So LD 916 is an act to protect data privacy and security in elections, and was originally a concept draft. At the public hearing, the Secretary of State proposed replacing the concept draft with an amendment to the statute that governs access to and use of information contained in the central voter registration system. Under current law, information in that system is confidential and generally may be accessed only by municipal and state election officials for the purposes of election and voter registration administration. Several exceptions to the confidentiality provision for CVR information are set forth in current statute, and the Secretary of State's proposed amendment to this concept draft would change some of those statutory exceptions to the confidentiality. So the first portion of the proposed amendment, although I don't know if it makes sense for me to also talk about the amendment to the amendment, but maybe just for background to go through this and then add on top of it what is changed since then this morning.
That works, yeah, thanks.
Okay. So at the public hearing, the proposal was to amend a provision that's in paragraph B of subsection 1 of the statute. So under current law, a political party, an individual or organization involved in get out the vote or other campaign activities, or a municipal, county, state, or federal elected or appointed official can purchase by paying the fee set forth in the statute the following CVR voter information from the Secretary of State or from the municipality if the request only involves municipal voters. So this is the type of information: the voter's name, year of birth, residence and mailing address, voter status and enrollment status, the electoral district or districts the voter's in, the date the voter registered and any dates for changes to the voter record, the voter participation history, the voter's record number, and any special designations for the voter, for example, if they're a township voter or overseas voter or military voter. Current law prohibits the recipient of this information from selling, distributing, or issuing, or using the CVR data received under this paragraph for any purpose not directly related to party, get out the vote, or campaign activities. The Secretary of State's proposed amendment would add a further restriction to this particular paragraph that would prohibit the recipient of the data from causing that data that identifies specific voters, which would include the voters' names, street or mailing addresses, to be made publicly available on the internet. So that involves just this particular provision of the statute about CVR data. The proposed amendment from the Secretary of State at the hearing would also establish a new exception to the confidentiality of this data that would authorize an individual or an organization seeking to evaluate the state's compliance with voter list maintenance requirements under the National Voter Registration Act to obtain the same CVR data that's listed in item 1 above. So all of these pieces of information, subject to the following restrictions. First, the disclosure must be pursuant to the National Voter Registration Act, a provision that provides sort of what information can be given. And then I would note that it talks about it can be at reasonable cost. So I presume that it can be charged for this data. In addition, under the Secretary of State's proposed amendment, which would add this exception, the recipient of the data under this paragraph may not sell, distribute, or use the data for any purpose not directly related to evaluating the state's maintenance obligations under the National Voter Registration Act. So that's parallel to the provision we talked about with parties receiving the data. They can only use it for the purpose for which they need it under the statute. In addition, this new provision would provide that the recipient of the data can't use information from the Central Voter Registration System that identifies specific voters and cause that to be made publicly available on the internet, again, parallel to the Secretary of State's proposed amendment for political parties and others under the paragraph we talked about before. So that's that new provision, and it's going to also be applied to this new exception. In addition, the proposed amendment establishes a civil penalty of not more than $1,000 for a first violation and not more than $5,000 for a second or subsequent violation of any of the CVR provisions in current law. The amendment also provides that a separate fine may be imposed for each instance and when an individual voter's identifying information is made available on the internet. As far as other provisions of law that are in current law, so other provisions that govern access to information about voters that's in the Central Voter Registration System, there isn't a chart outlining all of those exceptions to the general confidentiality provision, telling you what particular pieces of information about voters each specific individual who's listed in an exception to the confidentiality provision. So it outlines what specific piece of information they can get, whether they have to pay for it, and whether there are any restrictions on their use of that information. I put that in there to help you answer the questions to the technical issues I raised below. And then if you are interested in understanding the voter list maintenance requirements of the National Voter Registration Act, since that is part of the proposed amendment, I did provide some resources from the Department of Justice and then the National Conference of State Legislatures. And I am sure if you have questions, the people from the Secretary of State's office who are here could answer them better than I could. So as far as technical issues, although I wrote it above because I think that's the intent that the penalty provision would apply to anyone who violates the confidentiality provisions for CVR data. The way it's actually, oh, sorry, I'm getting to my second point, so I'll go there first. It's actually written as anyone who violates the provisions of this section. So anything that's within section 193-A. And that would include a requirement that the Secretary of State or a municipal clerk or registrar of voters has to respond to a request for information within 5 days. And I'm not sure that the intent of the amendment is to impose a $1,000 penalty for a first violation of that 5-day requirement or $5,000 penalty for subsequent violations. It may be the intent, but I think it was more about violating the confidentiality provisions. So I just wanted to ask that question. As far as the first question I had here, sorry to skip around, the Secretary of State's testimony indicated that the goal is to prevent anyone who gets the data from the Central Voter Registration System from posting it on the internet in a way that can identify voters. But the proposed amendment only imposes that limitation on the political party and get out the vote folks and upon the people who receive the data for national voter registration, or for ensuring that list maintenance activities are conducted correctly. So I didn't know, and that's why I included the chart, whether there's anyone else you want to prohibit from putting it on the internet. Oh, that's the question here. And then also, just so you know, there are some ways that the amendment is written, which I like the way that they flow together, but we're not allowed to draft it that way. So if you do see this back for language review, if you vote in favor of it, it will be structured slightly differently, but it would not be my intent to change the substance. So I would just want to alert you to that fact. Okay, so then here's the chart. So for example, if you're thinking about who can't post something to the internet, I doubt you would want the individual to be prohibited from posting their own record on the internet. That wasn't what I was intending to suggest. But this paragraph B is the political parties and the get out the vote information. And the amendment would say they can't post that on the internet. But there are, for example, caucus releases of central voter registration data, and that has a lot of personal identifying information as well. But the prohibition about posting on the internet does not apply to this provision, for example, under the proposed amendment. The next provision within the current law talks about absentee voter lists, and those can be released to any person in certain different formats. And I did know some of these have personal types of information, and whether those are supposed to be prohibited from being posted on the internet. So I just wanted you to see, and maybe the way it is fine, but I just wanted you to know what the scope is of the law currently. Just because of the way the testimony was written, I wasn't sure how far it was intended to go. And I can, of course, draft it however you want it to be drafted. This morning, the Secretary of State did submit an updated amendment that's also posted online. And I did forget to tell you that there is an emergency preamble. So I should have written that when I was getting ready to send this to you last night. So the emergency preamble is also on the proposed amendment from the public hearing. So either way, she's proposing an emergency preamble. But what this update does is it has the same information about prohibiting somebody who's in a political party or a get out the vote effort who receives central voter registration information. They're also going to be, just as they were in the original amendment, going to be prohibited from putting it on the internet or making it accessible to the public through other means as well. So that's different. There's also going to be adding a prohibition on transferring the data to another person or any information derived in part from that data, from transferring it to another person or selling or distributing it. So that's slightly changed. Although they would be able to transfer for the information to their members or volunteers. And I believe the Secretary of State this morning, she communicated to me that she might also want to add in an exception so that the party could not just transfer it to its volunteers, but also its employees. So I think that'll be an additional word that she's proposing to add here. In addition, she has similar amendments proposed to the new provision that would allow people who want to ensure that to evaluate the state's compliance with its list maintenance obligations under the National Voter Registration Act. There would be similar amendments to the way that language is written about you can't transfer the data in whole or in part to another person. And also you can't publish it in a way that identifies specific voters, either through the internet or other means. And then there is a new provision in the updated amendment from today, which states that it would be unlawful for anyone who accesses information from the Central Voter Registration. So this would be anyone in the entire chart that's attached to the bill analysis from using that information to engage in discrimination on the basis of physical or mental disability, race, color, creed, age, sex, sexual orientation, religion, ancestry, or national origin, and then including but not limited to any type of discrimination that's prohibited from a variety of federal anti-discrimination laws that are listed here, including the ADA, the Rehabilitation Act of 1973, Title VI of the Civil Rights Act of 1964, the Age Discrimination Act, the Omnibus Crime Control and Safe Streets Act, and Title IX of the Education Amendments of 1972. I have not had time to look into any of these, but I do understand them to be general civil rights legislation, anti-discrimination legislation. Also, the data could not be used to violate or to engage in discrimination that would violate the Maine Human Rights Act, and then any of the regulations promulgated thereunder. And then the penalty provision would be amended in a way to make clear that it also applies to this provision. So as a technical thing, I spoke to both the current revisor of statutes who consulted with the former revisor of statutes just very quickly this morning after I saw this language. And there is a delegation problem here. So ordinarily, as you understand it, your role as a legislature is to make the laws for Maine. Every once in a while, there are ways that you can delegate that authority to an administrative agency, for example, to adopt rules that are in accordance with certain guidelines that you give the agency about how those rules should be adopted. But in this provision right here, you would be delegating to the federal government and then any of its agencies that promulgates regulations under these laws adopted by the federal government. You'd be delegating to both Congress and those agencies the authority to amend any of these acts and thereby change a way that somebody could commit a civil violation and be assessed a penalty under Maine law. And generally speaking, that violates or could be considered to violate the non-delegation principle, where it's the legislature that sets the laws of Maine, not Congress and federal executive agencies that pass regulations. If that is a concern to you, the way that the revisor's office drafting manual generally recommends such provisions be written is that you pick a specific date. So it would be anyone who violates these laws or the regulations as of today. So we'd cite these laws all with a 2021 version. And then should those laws be amended in the future or the regulations be amended in the future in a way that is very important to the legislature to capture, you could pass new legislation that would then reset the date upon which you want this provision to be dependent. This is not a requirement. You can obviously pass it this way if that's what you wish to do. It's just a possibility that somebody could challenge us as violating the non-delegation principle. Then they also raised to me the potential that somebody might not be on notice by just reading this Maine law, that maybe a regulation was changed and that therefore the way that they're violating the law is changed. So that's another possible thing to consider when you look at this proposed amendment.
Great, thank you, Janet. I'm sorry if you already explained it, but in dealing with the delegation issue, if we did it at one moment in time, that kind of deals with that changing dynamic.
Correct. If you authorize me to draft it sort of the way the drafting manual recommends, which is to cite this year. So it's these laws as of this year. And then should they be amended in the future, or should the regulations be amended in the future? And it's in a way that is very important to the legislature to capture, then that can then be legislation changing the year that's used. You are going to see statutes in the main revised statutes, though, that do say as amended. So it can happen. It's just if you want that potential issue to be out there and that vulnerability to be out there, something for you to consider.
Right, that could lead to challenges if we don't, or potentially, or yeah.
I don't know how successful they'd be. I didn't have time to research delegation this morning, but
no, I appreciate your work, your very quick work on the fly this morning. Representative Corey.
Thank you, Mr. Chair. I still have some concerns with this. I think, namely that when I asked the Secretary of State the last time around if this had ever happened in Maine, the answer was no. And then they said they'd get me examples of where this had happened in other states. And they said they'd get it to us, and they never got it to us as far as I know. And it doesn't seem like Janet has that in her analysis either. I think of, situations where people may be sharing information, working on campaigns, working in things like, Google Docs, and if they, don't, flip the privacy off in the correct way. And I'm not saying they shouldn't have the responsibility, to do that or anything else, but I could see how, that could, potentially happen, sort of very easily. I look at the civil violations, in this law, the very first one being $1,000 fine, and the second one being not more than $5,000. And, that's, a substantial, amount of money, especially for an individual that may have inadvertently done something like this. And we've encountered this a little bit in other laws that we've debated in this committee. I think, mainly the one with regard to sort of foreign influence on referenda campaigns. And we talked about sort of the mens rea, of sort of what happened, meaning, the person's culpability. Did they knowingly, release the data? Did they intentionally, to release the data? So I'm feeling like $1,000 fine and a $5,000 fine for somebody that potentially, I'll be honest with you, if I get hit with $1,000 fine for, not knowingly releasing data, I would probably never ever put anything on the internet again. But regardless of any of that, I feel like the fines are steep in this for somebody that may get caught up in something that they don't realize is there. We've talked about it in this committee before, especially with regard to other bills, like why are we doing something if we haven't shown that it's occurred in Maine, in any way. I just have those sort of concerns surrounding this bill. Thank you.
Thanks, Representative Chiazzo.
Thank you, Mr. Chair. I'm happy taking Janet's recommendation on the delegation issue of adding the date specific, if that helps. I think that might be a good workaround following the normal guidelines for drafting. I think I would certainly be amenable to that.
Senator Hickman.
Thank you, Mr. Chair. I have actually just a question about that, or maybe not a question. In other parts of statute, Title 22 comes to mind. I just looked it up again. It's sort of my bailiwick. It's the food code. We refer to federal statute and rules and regulations in statute all the time. And the federal acts are laid out there. The rules that are promulgated by those federal acts are laid out there, and they have the force of law in Maine statute because we put them there. And so I don't know if there's been a change in this notion of how we stay away from that since those laws went onto the books. And if I can, I'll be clear, because I know Janet loves clarity. I'm gonna see if I can just put in the window what I'm talking about so we can see if it's the same or different here. Here is one provision of law.
If you tell me the site, I can screen share it.
It's right here. I just put it in the chat box.
I think if Janet, if you can screen share, we try not to put anything substantive in where the public can't see it.
Yeah, that's that's fine. I just wanted to at least let her know what link I was talking about so that when she can screen share it, it would be possible for us to look at. So in this chapter section of law, you can see how it refers to the federal regulations of certain things. To the extent that the regulations designate the information confidential, the information is otherwise identified pursuant to the regulations as confidential, or the regulations require the information to be protected from public disclosure. That's just an example, but there are more references to the federal acts in this particular part of law in chapter 551. If you go to the definition section of this chapter, you will actually see the federal acts defined. And so when they're used throughout the law, it's directly referring to those acts. And when those acts are amended, that's downloaded literally right into our statute, into our food code. And so is there a difference between that and this?
I haven't looked at all of the other provisions, but if you look here, this is the regulation as of 2008, the same down here as of 2008. So if they amended it after 2008, it is not the law in Maine.
Got it.
So, and there are provisions, you will find them in other statutes which talk about a federal law as amended. It is just recommended not to do that, to create a delegation issue. Sometimes that's the will of the legislature, and that's the way we'll draft it. We will draft it the way you want, but this does not have a delegation issue because this is just shorthand. This is saying we agree with this, and instead of writing it all out, we're going to cite it.
Yep.
But it's this as of 2008.
Can you turn to the definition sections of this chapter 551, please? So item 3 says that. Does that mean that any reference to the federal act is subject to the amendments of the federal act, or is there something in here that handles the delegation requirement or concern?
So I would have to look at each one and whether it has, because this could just be shorthand, and then there's going to be a year cited or not, I don't know, in each one, or but if it is intended to be as amended, then that's fine, and that's the way it's done in this section. And it was confirmed to me from the revisor's office this morning that this does happen. It has happened before. It's just an issue that you should be aware of, and whether you want to create the issue or not is up to you.
Okay. I guess with that, we don't need to stay in Title 22. Thank you, Janet, for sharing your screen. I guess because these are federal laws that characterize certain groups of people for the purposes of making sure they're not discriminated against, I suppose a future Congress could strike people off of that list, but they tend to get more inclusive than exclusive. In any event, I would think that we could just decide if we use it, if we put the year now, or if we allow those amendments to be downloaded, because things change at the federal level sometimes in a way that is more expansive than current law is. But either way, I'm fine. I just didn't know if this was a normal, if there were times when we passed statutes where we referred to federal acts that we didn't actually demarcate the year. And so we would, yeah, so we would be taking in all the amendments as they come through those federal acts that are in state law. Is that correct?
Depending on how it's written. So if it's written with as amended, then you would be. And if it's written with a year, then you wouldn't be.
Thank you. I like being educated.
No problem.
I learned that this morning as well. So Secretary Bellows, I know you're here. Just wondered if you would want to address, we'd heard just some concerns on why this is necessary, if you can kind of elaborate on that.
Yes, so federal law does allow groups, in addition to parties and campaigns, to receive voter registration data. And so that's the purpose of adding the provision to expand who may access voter registration data. But federal law is specific that that's for purposes of reviewing list maintenance practices or voter registration practices. So we wanted to be specific about that. And what we also wanted to do was to make sure that there were strict limitations on prohibiting the sale or distribution of the data to third parties or any practices that might result in taking this personal, confidential information and using it in an appropriate way. And I want to respond to Representative Corey and apologize for not following through in a written communication from my office. In terms of examples of potential misuse of data, I think, one, we're trying to be proactive. We want to make sure that we're well aware that big data is big money, and that this is sensitive, confidential information, that the voters have an expectation that when they register to vote, that the data won't be used for other purposes. So from that perspective, that's our intent. In terms of examples where voter registration data has been misused, I'm sure that they exist. I know there was a case in New Jersey where voter information was wrongly published on the internet, and legitimate voters were targeted, accused of being illegitimate, but not by the state of New Jersey, not by the Secretary of State of New Jersey or by elections officials, but outside interests. And so that certainly would be of concern. That is something that we wouldn't want to see that happen. And I think the non-discrimination provisions, we are comfortable making any sort of adjustments that need to be made, but those are important as well.
Great. Thanks. Thank you, Secretary Bellows. Any further questions? Representative Corey.
Thank you, Mr. Chair. I mean, I certainly don't want to see us, have it so that, people release, data for, vindictive, purposes and everything else. But on the flip side of this, and, I think as probably a former ACLU, attorney, you would probably have to be a little bit concerned about some of the civil violations, that could, go along with somebody, not knowingly, intentionally, or recklessly, inadvertently putting, data out there that they didn't intend to do that. So I do, hear that, this is really targeted at, one, people that would use it for a malicious purpose, right? Or number two, people inappropriately using this data to sell or for third-party interests and everything else. But I just want to make sure that nobody gets caught up, that may have, just done, a dumb thing like put something on, Google Docs as they were working on their campaign,
right.
And that somehow they didn't create the correct privacy settings, that would then, set them up for a civil violation. And we all know that if we don't, pay our civil violations, those things can actually turn into criminal, penalties and sort of everything else. So I want to make sure that we're not jamming people up in the legal system, inadvertently through creating a law like that. And I hope you can appreciate and understand that.
I thought the suggestion to add the word knowingly is a good one, because I think that you are absolutely right. The intent is not to catch up a candidate who, to your point, Google Doc is a perfect example. We're not looking to punish people for genuine mistakes. We want to prevent people knowingly selling or distributing this data or using this data to discriminate against people or target people. So if we added knowingly, I'm not an attorney. I used to joke that I used to play one on TV.
I thought you were. I thought that was you're just a lobbyist then.
No, I was just the executive director. I had attorneys who worked for me, but I'm not an attorney. But so Janet who's more experienced in statute drafting than me might be able to assist us. But I think the word knowingly would address your concern. So.
Okay, thank you.
Thanks. And yeah, I agree. I like that recommendation just to make sure we don't hit somebody accidentally if they put up, who knows, something online without realizing. So I think that's a good suggestion. Representative Chiazzo.
Thank you, Mr. Chair. In light of that, I will move ought to pass as amended, including Representative Corey's suggestion of adding the word knowingly and Janet's recommendation in terms of dealing with the delegation issue per the standard drafting guidelines.
Okay, a motion of ought to pass as amended by Representative Chiazzo. Is there a second?
Second.
Janet has a question.
Seconded by Representative Tuttle.
I have a question as well.
Yeah, and Janet, did you need clarity on the motion? Sorry.
Sorry, I'm writing down who made it and seconded it.
Yeah, it was Chiazzo and Representative Tuttle.
So I just didn't know the way that the amendment is written, any violation of this section at all is subject to a $1,000 penalty, and the section requires responses within 5 days by the Secretary of States and municipal clerks. I didn't know if you wanted that to be a violation as well. Just basically the technical issues, whether they were technical issues to you or not, or whether that is what the intent was. So I didn't know if you had any thoughts on those. If they're all fine the way they are, I'm fine with that. I just wanted to check what you thought.
Can you say the first one again, Janet? Sorry.
So they're all like I wrote them in one order and totally talked about them in a different order.
Sorry.
The thing I just said was the penalty provision says any violations of this section. And this section includes a subsection that says that you have to respond to requests for central voter registration information within 5 days. So if a municipal clerk is overwhelmed and doesn't get back within 5 days, they would be subject to a $1,000 penalty. And if they did it twice because perhaps they're overwhelmed a lot, maybe they don't have enough staff, then they'd be paying a $5,000 penalty.
Yeah,
Thank you, Janet. It's an amazing catch as always. Yep, sorry, Representative Chiazzo.
Thank you, Mr. Chair. I mean, I'll defer to the secretary what her intent was, but I certainly don't want to be penalizing clerks. I think it was, I understand the intent was to penalize those people who knowingly abuse the data. So I don't know what that would look like in terms of drafting, and would be happy to take your input on that.
I would limit it to violations of subsection 1.
Okay, I'm comfortable with that if the committee is.
Good on your motion. Great. Senator Hickman.
Oh, my hand is still up. I'm sorry. Yeah, I was making sure that we weren't putting the penalties on the whole section because it was clear to me that wasn't the intent. So it looks like this will solve that problem.
Great. All right. Any further questions or discussions on this one? All right. Seeing none, we'll proceed to a vote. The motion before us is ought to pass as amended. And Karen, can you please call the roll?
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren. You can come back to Senator Farren. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. I can come back to Representative Kinney as well. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dollop. Representative Dollop, absent. Senator Farren. Senator Farren, absent. Representative Kinney. Representative Kinney, absent. 9 in favor of the motion, 0 opposed to the motion, and 4 members absent, Mr. Chair.
Great. Thank you, Karen. So 9-0 unanimous of those present, and anyone absent will have until tomorrow, or I guess Monday at noon. Oh, Tuesday, that's right. Get extra time to vote. Thank you, Secretary Bellows, for your help on that.
Thank you, everyone.
Senator, we're having a cookout, right, on Monday?
I'm out of town all weekend. We'll have one somewhere, though.
I don't know how he can eat so much grilled food. It's weird, Tuttle. It's weird.
I could live off a grill. I guess, Janet, next on our list is LD 1726.
We did have a work session before. I was instructed to see if the AD's office had time to reply. I don't think they did have time. So I don't know what you would like to do.
Okay, thank you. Yeah, it's, yeah, I don't think we have time, obviously, for it now. The question is what to do if we wanted to either not to pass it or carry it over. Obviously, we actually have an not to pass motion on the floor. Representative Tuttle.
Chairman, I move that we would carry this bill over.
So Representative Tuttle, we first have a motion about not to pass that's on the floor, so we can deal with that one first. I don't believe the carryover motion takes precedence, so maybe we deal with the odd not to pass, and then we can, if it fails, we can make a motion to carry over. Sorry about that. Any further discussion on this one? Representative Corey.
None of my members are here right now. So I'm a little concerned about my ought not to pass motion right now.
Do you want to take a minute or do you want to go for it? Oh, we got one.
I don't care. I mean, if it doesn't carry, do you know what I mean?
Yeah.
It's going to be what it is anyways. I mean, I'm outnumbered for sure.
We may all end up there, but I don't mind a little more time. Okay, so the motion before us is ought not to pass. Karen, can you please call the roll?
Senator Lucchini.
No.
Senator Lucchini, no. Senator Hickman.
Nay.
Senator Hickman, nay. Senator Farren. Representative Chiazzo.
No.
Representative Chiazzo, no. Representative McCray.
No.
Representative McCray, no. Representative Tuttle.
No.
Representative Tuttle, no. Representative Riley.
No.
Representative Riley, no. Representative Supika.
No.
Representative Supika, no. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dollop. Representative Dollop, absent. Senator Farren. Senator Farren, absent. 3 in favor of the motion, 7 opposed to the motion, and 3 members absent, Mr. Chair.
Okay, thank you, Karen. So the motion being 3-7, the motion of ought not to pass fails. Representative Corey.
So we're in kind of a funny place here right now because we just had a motion and we had a vote, and we've got what a 24-hour period by which people are allowed to cast their votes. So I don't know what we do with that, especially since we'll be taking another vote procedurally. Regardless of that, sort of my concern is just, I mean, like what, usually if I'm going to carry something over, I like a little bit of direction as to what we're going to do with something in order to make it better or more palatable. Do you know what I mean? Or better able to win. Do you know what I mean? a positive vote. Does anybody know what we'll be doing to this to try to make it a little bit better?
Sure. Well, I
Thank
guess
you.
just on the first point, the motion failed, so we don't leave the jacket open when the motion fails. Representative Kinney, did you have a question? Yeah.
Yeah, it was on the motion idea. Even if it were to everyone were to come in and vote on it, it still would end up only being 7-6. It would still be a failed motion. So the motion fails regardless of the jacket. If we were closer, if there were less than a majority on the on the minority, well, yeah, going opposed to the motion, it's not a majority. Well, yeah. So there was a majority on that part, so the motion fails in reference to that. But I'm on with Representative Corey. I would want a lot more information as to why we're carrying it over. I think we should have a very good reason for carrying it over, and I don't think we have that.
Thank you, Representative Kinney. Representative Chiazzo.
Thank you, Mr. Chair. I'll weigh in as to why I'm about to make the motion to carry over, and that's because I think that certainly on there are potential abuses out there. I think we've all experienced that. I think this is a topic that is in the purview of this committee, and we should give it its due diligence and really explore it first, rather than just killing it for the sake of time and running out of time. So I think I'd like to give us more time to do the due diligence on the bill, dig into it. We may end up being in a not to pass at the end of the day. We get feedback from the AG's office and we have a further debate in the committee. But I think it's the issue is important enough to hold over. So I will motion to carry over.
Okay.
Second.
Motion to carry over by Representative Chiazzo, seconded by Representative Tuttle. And I'll just echo Chairman Chiazzo's comments. I think we've seen an increase in a lot of, especially social media, misleading stuff. And if there's a way we can better disclose it for people, I think it's worth investigating when we have more time. Representative Corey.
Thank you, Mr. Chair. Well, I'll say that it is in this committee because it was assigned to this committee. I really don't think that it really reflects what the purview of this committee is in a lot of ways. What we're doing is we're looking at, speech that's done by, individuals that probably isn't expressly advocating for or against a candidate, just a political figure. So I'm not sure that is the purview of this committee. I think that when we're dealing with the actions of 501c4 organizations, I think that, and we're talking about speech issues, I think that that's stuff that should actually be landing in the judiciary, committee. Once somebody expressly advocates a position, yes or no, for a candidate or referenda or an initiative or whatever it is, all of a sudden it does become, campaign speech, and it becomes something that, falls, under the Ethics Commission, which certainly is the purview of this committee. So I'm not sure that we're here to look at free speech issues. That's certainly not within what the scope of this committee is.
Representative Kinney.
I apologize. I didn't put my hand down.
Oh, sorry. Senator Hickman.
Thank you, Mr. Chair. I'm going to respectfully disagree with my good colleague from Wyndham. I think that political speech, we are always looking at issues of free speech in this committee when we think that we may or may not do something that will infringe upon that right. That political speech. Political campaigns is got the highest protections under the Constitution and the law. So those bills do come before us. But the other thing is that even if they don't, committees re-refer bills all the time. And if this bill is carried over and the amendments that are proposed to make it better fall under the purview of a different committee, this committee is free to then re-refer this bill to that committee, but it gives us more time to look at an issue that I do believe is very important because the landscape in social media changes. We know the power of misinformation. We know people believe what they see. We know they don't always go deeper into it. And if something looks like it's official or it's a news item and it's there to influence political behavior, I see no reason why we should not give this bill a little bit more attention, because it is absolutely an important matter as far as I'm concerned. So I will support the motion to request and carried over. Thank you.
Hey, Senator Farron.
Yeah, I apologize. My connection today is not the best, but I'll just throw in a couple words, and that is, I think this has been a strange session doing remotely. I think that we've moved a lot of things along without a lot of discussion and time and notice. I mean, even this meeting today, right? We didn't know that what was going on, what was going to be on the agenda until last night or this morning. And so we are under a workload piece and going back in. But with that being said, we've had some bills that tried to address some of these things. I think of Senator Stewart's bill and some other things that we disposed of. This came in after deadline. There are some of those concerns. And I just say, listen, elections have consequences. The majority party has a rule in how some of these things go. I honestly believe that if this wasn't the Senate President's bill, if this was a partisan bill, that we wouldn't be having this discussion, that we would dispose of it. And I just think we got enough work that we're carrying over, and a lot of important work, and there's always other times for that. So I just hate to see that be part of the discussion, but it's just the way I feel.
And yeah, and I think there's a lot of work before I'd ever support this thing as drafted. So is there any further questions? You good, Senator Farron? Yeah. Okay, seeing none, the motion before us is to carry over LD 1726. Karen, can you please call the roll?
Senator Lucchini.
Yes.
Senator.
Got it. I got you.
Senator Lucchini. Yes, thank you. Senator Hickman.
Yay.
Senator Hickman. Yay. Senator Farron.
Nay.
Senator Farron. Nay. Representative Chiazzo.
Yes.
Representative Chiazzo. Yes. Representative McCray.
Yes.
Representative McCray. Yes. Representative Tuttle.
Yes.
Representative Tuttle. Yes. Representative Riley.
Yes.
Representative Riley. Yes. Representative Supika.
Yes.
Representative Supika. Yes. Representative Wood.
Yes.
Representative Wood. Yes. Representative Kinney.
Nay.
Representative Kinney. Nay. Representative Harrington. Representative Harrington. Absent. Representative Corey.
No.
Representative Corey. No. Representative Dollar. Representative Dollar. Absent. 8 in favor of the motion, 3 opposed to the motion, and 2 members absent, Mr. Chair.
Great. Thank you, Karen. Okay, next up on our list, we do have a language review on, while we're on election stuff, on 1417. However, that was my bill, and it was fairly a bit controversial. Or a couple elements. I was wondering if people were open to it, we'd be able to reconsider, and then I can potentially amend it to hopefully clean up a few things. So Representative Chiazzo.
Thank you, Mr. Chair. I believe I was on the majority side. I will move we reconsider 1417.
Second.
Okay, motion to reconsider 1470 by Representative Chiazzo, seconded by Representative Tuttle. Any discussion? I'll just say the rationale being we did receive a memo with some issues from the Ethics Commission that I was hoping to clean up and send out. So seeing no other discussion, Karen, can you please call the roll? The motion before us is to reconsider LD 1417.
Senator Lucchini,
Yes.
Senator Lucchini, yes. Senator Hickman,
Yay.
Senator Hickman, yay. Senator Farren, Representative Chiazzo,
Yes.
Representative Chiazzo, yes. Representative McCray,
Yes.
Representative McCray, yes. Representative Tuttle,
Yes.
Representative Tuttle, yes. Representative Riley,
Yes.
Representative Riley, yes. Representative Supika,
Yes.
Representative Supika, yes. Representative Wood,
Yes.
Representative Wood, yes. Representative Kinney,
Yes.
Representative Kinney, yes. Representative Harrington, Representative Harrington, absent. Representative Corey,
Yes.
Representative Corey, yes. Representative Dalla, Representative Dalla, absent. Senator Farren, Senator Farren, absent. 10 in favor of the motion, 0 opposed to the motion, and 3 members absent, Mr. Chair.
Great, thank you, Karen. So we've reconsidered LD 1417. So basically I sponsored this. Director Wayne had submitted a memo, which maybe Janet can call up if you have it handy, but basically laying out kind of an option of how we can do this because there were concerns about, I think mine was really restrictive on, yeah, so the option one there, restrictive on the transfer. This was the corporate contribution ban, sorry, by the way, Bill. So the recommendation here I think, which would allow PACs and party committees to contribute to candidates up to the same max amount as individuals. I think it's hard to prove that there's like a corruptible, I guess, effect when it's in the same party. And that's something that was raised in the analysis as well, and I missed it. So basically, what I would recommend making the change, and I know it may not change the votes on how it fell anyway, is I would make, I'm not making a motion from here, but I think I would take option one, and given some of the concerns that I heard and to make it more defensible, I'd also change the portion about labor and have labor treated the same as corporations to put it out in that spot. That way it doesn't look like we're giving any unequal treatment, and both can use an SSF fund to contribute to candidates. So I think the combination of the two, with working with Director Wayne and consulting the AG's office, would make it a more defensible bill. So those two changes, I think I would support, and if people were good with that, we can make a motion. And again, I don't anticipate this will change a lot of votes, but I did want to ease some of the concerns of some of the opposition side. So thank you, Janet.
Do you want me to unshare?
Yeah, sure. Thanks, if you don't mind. Senator Hickman.
Yes, thank you, Mr. Chair. I will make a motion ought to pass as amended with the suggested amendment put forth by the bill sponsor, sir. And I just want to say that I appreciate these changes because equality before the law is a principle that should be upheld in every situation where possible. And it just seems to me that if we're going to make some rules for one entity, it should apply to others as well. So I appreciate this amendment, and I'm actually even more comfortable voting for it now. Thank you. So my
Second.
motion passes amendment.
Thanks.
Yep. Second, Mr. Chairman.
Thank you, Representative Tuttle. So motion ought to pass as amended by Senator Hickman, seconded by Representative Tuttle. Representative Corey.
Thank you. I feel that we would need to caucus this.
Okay, do you want to take a few?
Yeah.
Okay, why don't we take, oh, sorry, Janet has a quick thing that may help.
I don't know that it will help, but so it's my understanding you want all of the provisions of the original amendment with this layer on top. Right? Okay, just checking.
Sorry, yeah,
That is my motion, yes.
Thank you.
great. So Representative Corey, do you think like 15 minutes? Something like that? Okay, so we'll come back around
Yes.
11:35, 11:40-ish, and same length for people if you leave the meeting. So, great. Senator Hickman, did you have a quick? Okay, all right, we'll take a 15-minute recess.
Hey,
So
I have to
let's-
head to another.
And then we can get started back in case we vote. So sorry for the delay to the people in the waiting room. This is the time of year where our members are in multiple committees and super busy all at once with bills, other committee hearings and everything else. So thanks for your patience.
Senator Lucchini, while we're waiting, can you remind me who seconded the motion? Because I didn't record that.
I have Representative Tuttle.
That's what I have too.
Thank you.
I'm here.
All right, we'll get restarted. Thanks again to everybody who's waiting, and we'll let some more people trickle in. Representative Corey, did you have?
Yeah, I've got about 3 minutes before I have to be somewhere else. If we want to vote on this one.
I'm sorry, I missed it. I had my speakers on mute.
Sorry, I said I've got about 3 minutes before I have to be somewhere else.
Okay, sorry. Yeah, no, I know everybody's got a lot of committees meeting right now, so.
I think we have 7 at the moment. We could open and then we can discuss, and hopefully we'll keep 7 for voting.
Sure, yep. Okay, we've got 7, so let's go ahead and roll. I think so we're on LD 1417. And the motion before us is ought to pass as amended. That was made by Senator Hickman and seconded by Representative Tuttle. Any further discussions on that bill? Okay, seeing none. Again, the motion before us is ought to pass as amended, so we can proceed to a vote. Karen, if you would please, oh, hold on just a second. Representative Corey.
Real quick. So I plan on sticking with my original vote, and I think that my caucus may feel the same. It's not that we can't come to support this bill out on the floor, but we just need to try to better figure out what it's doing and everything else. So, even though, I'm just going to say we may be voting no, there's a good chance that we actually support it, on the floor. So I just want to make that clear. Thank you.
Sure. Thank you. Yeah. And I apologize. It kind of came last second. So on the last day. Any other discussion? Seeing none, the motion is ought to pass as amended. Karen, can you please call the roll?
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren. Senator Farren, absent. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
No.
Representative Kinney, no. Representative Harrington. Representative Harrington, absent. Representative Corey.
No.
Representative Corey, no. Representative Dolliff.
No.
Representative Dolliff, no. 7 in favor of the motion, 3 opposed to the motion, and 3 members absent, Mr. Chair.
Okay. Thank you, Karen, for
I
that.
confirm the minority report.
Yep.
I not to pass.
Thank you.
Thanks. Okay, next on our schedule. Okay, we have the block of sports betting bills. And again, if people need to caucus midway through, we can do that. Representative Tuttle.
Mr. Chairman, has it been thought about maybe using one of the bills and disposing the other ones? I would recommend that as trying to make this as less confusing as possible.
Yeah, I think that's a good idea. I don't know how it's going to end up falling out, though. Representative Kinney, it's becoming controversial as usual. So, yeah.
Thank you, Mr. Chair. I'd be okay with that, but I don't want to just dispose of bills until we pick one. I'd like to vote one out before we dispose of any additional ones.
And I think we do have, people have offered proposals, obviously. So I guess I can speak broadly on a proposal that I would consider offering to people. Sorry, I'm just reading my notes.
That's 1552, Mr. Chair. Is that correct?
1352.
1352. Thank you. Yeah.
I don't know, generally, Janet, if you had anything you needed to add either, or are we good just to go? We've worked these a couple of times now, I think.
Just wanted to point out that you had asked for a proposal from the Gambling Control Unit Executive Director Champion, and he did send that along. I emailed it to everyone, and it is posted online for the people listening online. Also, Senator Baldacci had a proposed amendment that is posted online again, and I sent to you all, and he also sent it to you all as well. So those are the only updates from me.
Okay, thank you, Janet. Representative McCray.
Thank you, Mr. Chair. I may be jumping ahead, but though I'm usually in favor of putting bills together, I would not want to do that this time. I would like a chance to take up one of the other bills as a possibility. So I just wanted to put that out there.
Sure. So Representative Tuttle.
Mr. Chairman, if you could briefly go over how you wanted to have 1352 amended, it would be helpful to me.
Sure, thank you. Yeah, and I understand these are all controversial and probably everybody's phone's ringing nonstop at the moment. And of course, we can insert anything we want into minority majority reports, but if people don't want to do that and want to run separate bills, we can do that as well. But I know Janet's done a great job as always in giving the breakdowns of each bill. And so, I think we can work through some of the charts that explain the differences between the sports wagering bills and the common features. And obviously, having sponsored the bill last session, it got vetoed, obviously. So I've worked with the governor's office to try to find something that we could pass without getting a veto, or where we wouldn't have to require the 2/3 vote. So working with the governor and her office, we've come up with some language that's they can live with, and that we think they'd let go through rather than a veto. And that's kind of where I'd like to see something pass, and I'd like to see something not vetoed again. So essentially mine would use the framework of 1352 as the base, which Janet walks through all the common features in her analysis of all the bills. I would add a few things just so Janet knows. I would raise the licensing fee for mobile operators as the director recommended. I wouldn't go as high as the director. I think I would just go to 100,000 for 2 year to kind of get in the middle. But to be clear, just so I'm not trying to slip anything by anybody, this would be an this would not require licenses to be tethered to a brick and mortar. So this would be an untethered, technically, bill. This would prohibit betting on Maine college sports. Wanted to make that clear, just to preserve the integrity of Maine college sports. We would add a tax cascade for harness racing. I would take this essentially from 1405, that cascade to supplement harness racing purses, the Sire Stakes Fund, and the Agricultural Fair Promotion Fund from both of those, and insert it into mine. However, unlike 1405, I wouldn't cut gambling prevention funds. I would keep those at 1%, as well as the administrative expenses at 1%. In addition to that, and sorry, Janet, if I'm going quickly.
Does that mean you just reduce the general fund share?
Yep. And in addition, I would strengthen the language around marketing towards kids. That's something that's really important to the governor, and I agree completely, to ensure we have some provisions in here that strengthens that, and to make sure that there isn't advertising on social media and things, that these companies aren't targeting kids with their advertisements. And adding some of the language provided by the NFL around objectionable bets, so that we don't have situations where people are betting on injuries or the color of Gatorade or anything that could hurt the integrity of the game or the perspective from people of the game, as well as some of their, and this is from Representative Roach's bill, I think section 1215, which talks about abnormal wagering activity, to ensure that there isn't something suspicious going on. And I think in section 1217, the record keeping requirements. So that would be basically the changes made to the bill. And to be clear, this would still allow all the commercial tracks, any OTB, the casinos, and the tribes to have a physical location sports book. And it would allow them to also do mobile if they would like, but it doesn't require to be tethered. So other qualified gaming entities would be able to get licensed under Maine law. So they would go through the regulatory structure of the gambling control unit. And all the physical places could do it, but they're going to have to make sure. They don't have to have it tethered. So Janet, sorry.
I just want to clarify. You said two things that could have been reminders, but I was writing them down as amendments. So you said it prohibits betting on all Maine college sports, and that's already in there. So I didn't know if that was meant to be a change in how it's written. Like, for example, the thing about tournaments or whatever.
Just that any competition with a Maine team in it is what I would like to do. So
including the whole tournament?
No.
Okay. Then one more, sorry.
Yep.
You said to strengthen the language about not advertising to kids. So that is rulemaking in your LD 1352 as drafted. Are you changing that in some way, or are you just reminding people that that's in your bill?
I like it as in the bill with rules, but perhaps we can put it, is there a place we can put it into statute that works, that it says, just to be very clear, that companies can't market towards kids for sports betting.
So have it statutory prohibition and then details in rulemaking.
Yeah, I think that would be my preference.
Okay,
yeah.
Thank you.
To make it a little stronger. Okay, Representative Tuttle.
Mr. Chairman, if it's appropriate, I would move ought to pass as your amendment recommends.
Okay. So we have a motion about to pass as amended by Representative Tuttle. Is there a second? 1, 2, 3, 4, 5, 6.
Second.
Okay, seconded by Representative Riley. We can certainly leave plenty of time for discussion, and I know people will want to caucus as well, so certainly not trying to rush the vote. So Representative Chiazzo.
Thank you, Mr. Chair. I very much appreciate the hard work that you personally have put into this, not just in this session, but the last session as well. And I think it really comes down to the big question of tethering versus untethering. And I know I've got constituents in my district that are strong proponents of tethering. And while I can agree with almost every other aspect of the bill as you've come through and negotiated it and put it together, I think it's a great compromise, and it meets a lot of the needs. I'm hung up on the tethering issue, and I really can't be in a position to vote against my constituents. They're pretty adamant about needing that tethering aspect of it. So unfortunately, I'm going to be in the unfavorable position of not supporting this bill, in spite of recognizing the Herculean effort it was just to get us to this point. So, and I'm happy to keep that discussion open for the other bills as well. But I know that that's really the key issue, and I understand both sides. There's pros and cons to each one. I don't think tethering is the end all be all. I think there are certainly some downsides to doing it that way. But I also think untethering has some pitfalls as well. So from my perspective, looking at the pros and the cons of each one, I think tethering maybe with more skins for each location would be would probably be a more palatable approach for those in my district. Sure. But I do want to thank you for the work you've done. It's been inspiring to say the least.
Well, thanks. And I fully recognize people disagree, and this is one of those times when it will likely happen as last session. So we are short of a quorum. I think it probably would be a good idea for us to take a recess, unless there's further questions or anything that people want to say. Yep. Oh, Representative Wood.
I actually didn't want to say anything. I just wanted to say I was here and
Great.
Yeah, one.
Great, thank you. I know you're very busy with the Energy Committee as well, so yeah, I think we'll take some time to caucus. Looks like even though we have a quorum, it's all one party, so we should give a little bit of time to make sure everybody has a chance to talk about it. And then we can try to rally some more members to come in and vote. So I guess what we'll try to do, we'll take a recess till 12:30. And then hopefully we can rile up some more numbers, roughly 12:30. Generally it's later than that when we shoot out a time frame. And we can come back and vote. And then I think after that, after these bills, we'll move a bit out of order to get to the tribal gaming bill. That way, because I do believe we have some of the tribal chiefs in the waiting room or in the attendees list. So we don't want to have them wait around for a long time. So we'll take a quick caucus and then come back, and apologies to everybody. We have a lot of members serving in multiple committees, so we'll take a recess.
So when you say, well, we're not caucusing that at the moment. We haven't caucused.
Hickman, you're not muted.
Okay, once we get enough members back to vote, we'll come back and begin again. We're still short some. So once we get up to 7, we can keep moving. And just so people know, once we do the votes on sports betting, we'll take LD 554 next out of order. And then we'll go back to LD 1518. So once we get through the sports betting portion, we'll go to the tribal gaming, and then 1518, and then 2 o'clock we're slated for the 1242, 882, and 1319. So, and thanks for helping out, Deb. Okay, we've got a number of people back. So we can get restarted. Apologies to people watching for the delay. That kind of day here. We have a lot of busy members. So we do have a motion on the floor. Oops. A vote to pass as amended on 1352 by Representative Tuttle. If people have any discussion, we can discuss. Representative Kinney.
Thank you, Mr. Chair. I am curious. I apologize. I'm trying to do an end of season order for my business. I'm trying to get it before the sale ends. So I'm running around doing a few things at the same time. with this amendment, was there any tethered at all, or was it all untethered?
The one that this one that Representative Tuttle did was untethered.
Okay.
Yeah, no tethered licenses.
No tethered. Okay, I can't support totally untethered, but I would be willing to offer either a different amendment and a friendly amendment to this one where we had something similar to what Senator Baldacci sent to us, with some tethering with the casinos and the OTBs and the tribes, and then having a limit of 3 untethered, but no moratorium of 24 months. So I'm not sure how I'd want to do that, but that would be where I would come from on this. I would do kind of a mix to give a little bit of both. So is where I'm gonna fall on this.
Janet?
I don't know if you're speaking the same language as each other, which you probably are, and I'm just misunderstanding. But I think under Senator Lucchini's proposal, anyone can apply for untethered, and there isn't a maximum on it, but every casino, OTB, or tribe could also get a mobile license or a facility license. So if that's what you mean by a mix of both, then there is a mix of both. It's just that tethering is not required. So you can have a license as a mobile sports operator without having a physical presence in Maine. But if you have a physical presence in Maine, you can also have a mobile sports operator license, if that's what you meant. So I just wanted to make sure you were talking on the same page.
Great, thanks, Janet. I didn't explain it very well, sorry. So not in undermine, any of those locations will have a physical location, but they can also have an online one, but it's not required. So in that light, it's not a required tethering situation, but like the casinos who own their own platforms, they can have both a physical and an online one without the requirement. But it just doesn't require that you have to be tethered to be licensed within the state, but each one can have both. As Janice said, much better than I can. So I guess we don't have Representative Tuttle here. Representative Chiazzo.
Thank you, Mr. Chair. I just wanted to add my understanding, and speaking with some of the OTBs specifically, not necessarily the casinos, is the costs for them to do that as a standalone. It requires some expertise and a lot of investment upfront. And I think even though they might be allowed to do that as a standalone, I think that would be cost prohibitive for them to try and do that on their own. And I think that was the whole basis for, well, not the whole basis, one of the bases for the model behind the tethering structure, to allow those costs to be defrayed and shared.
Yeah, I think under the tethering model, all the people who are the brick and mortar licenses get a revenue stream from the online people, which I think is why they like it so much. Untethered, they could still work with an online one. If perhaps an online vendor wanted to have a physical sports book in the state of Maine, then they could do it like they've done in other states. But it is what it is. Senator Farron.
Yeah, just real quick, Mr. Chair. I mean, I go back, we've all bounced this around for quite some time, and I really appreciate the things that you brought forward, especially on the child protection pieces and the advertising piece and the main sports piece. So I'm really appreciative of that. It comes down to the tethered and untethered. I have supported tethered. I think we heard during the testimony and through the committee process. I don't think we really heard anybody speak, definitively against it. We heard a lot of folks speaking in favor of it. And so what I hope is we take this vote, see where that falls. I'm going to basically mirror your language and have the tethering piece in there would be a suggestion, and we move this thing on and keep the day grinding along, as they say.
Yep. Thank you, Senator. I'm good to move it along. I just don't want to force anybody to use this bill if they don't want to, because it looks like I'm kind of going to get rolled here. So Whatever, if you want to use this vehicle, we can. I don't want to force this one, but if we think it's cleaner to use one vehicle typically just for the production offices. So if people are good sticking with this one, we can vote and then make the minority reports, which could shift over. Or if you want to use a different one, we can use a different one. I don't really care anymore. So Representative Wood.
Thank you, Mr. Chair. As has been said, the tethering and untethering, I never even heard this word other than at the playground as a kid playing tetherball. So I've really spent a lot of time listening to the tethering, untethering. I keep moving back and forth. But I think I had some misperceptions at the beginning about how much tethering would help small businesses. And I think I've gotten to a place where it's really not that many small businesses. And it seems as though tethering is just adding a middle person that gets a slice of the pie. And I'm not sure really what they do. And I have had a conversation with two different constituents who do some gambling. And they talked to me about the fact that having something tethered allows the tetherer or the tetheree, the tetherer, the brick and mortar to just do a lot to incentivize people to gamble more, and that it does play into people that have problems with gambling. And so today I think I'm ready to go with the untethered on your bill as it stands.
Thanks.
Thank you.
Thank you, Representative Wood. Senator Farron? Okay.
Hand was still up.
I know, it's hard to do, especially on a phone. You're good, Representative Wood. Okay. So seeing no further discussion, I guess we can go to vote on this one if people are good with that. So the motion before us was made by Representative Tuttle, a vote to pass as amended, and seconded by Representative Riley. So Karen is out. So we have Deb Fahey here filling in for us. Thank you, Deb. So if you can please call the roll, that would be great.
Certainly. We're voting on LD 1352.
Yep, sorry. Yep.
Senator Lucchini.
Yes.
Senator Hickman.
Nay.
Senator Farron.
No.
Representative Chiazzo.
No.
Representative McCrate.
No.
Representative Tuttle. Is Representative Tuttle's not with us, so Representative Tuttle's absent. Representative Riley.
No.
Representative Supika.
No.
Representative Wood.
Yes.
Representative Kinney.
No.
Representative Harrington's absent. Representative Corey is absent. So that's 2 yes, 7 no, and 4 absent. I counted that right.
Sorry about that. Thank you, Deb. So if people want, we can do your reports here and flip the majority minority, or we can kill the motion, whatever people are good with. So Senator Farron, did you want to, or Representative Chiazzo?
Thank you, Mr. Chair. Yeah, I think we just flip the reports. I'd like to propose for the majority report that we just take the tethering language out of 1405, Senator Jackson's bill, and insert that into 1352. And I'm sure Janet's going to need all kinds of other clarifications, but.
So are you saying LD 1352 as written? or as amended by Senator Lucchini, only you're just striking out the untethered licensees.
Thank you, Janet. As amended by Senator Lucchini, just striking out the untethered language.
And thank you to my colleague who just brought me coffee. Wasn't that nice?
Okay, so, sorry, so are you good, Janet, with that amendment?
Yep.
Okay, and so does anyone else want to be on the amendment just offered by Representative Chiazzo? Okay, so we have Representative Supika, Representative Supika, Representative Riley, Representative Fair, Representative Kinney,
I would have a slightly different amendment.
Okay. So you're going to be on a different report, and Senator Hickman, are you?
Senator Hickman is ought not to pass.
Okay. And then, so Representative Kinney.
I like the amendment, but I'd like to limit, at least temporarily, to give a pilot on the untethered, to limit it to 3 for 24 months, at which point we can go unlimited. I don't know how that would work.
I don't know how that would work either, and I kind of need to know to draft it. Sorry. I don't know how they'd select the first 3 to apply, or.
So how do we do that kind of thing now, I guess, would be my question. And it would need to have that kind of.
It could be like an RFP, I guess, or something.
Yeah.
I think
I need to know what the selection criteria are so I can draft it.
Yeah.
So like the RFP for the ADWs, they were setting their own tax rate, and that's kind of how they were selected. And did they have enough protections? I don't get the sense you want them to select their own tax rate, so I don't know what you'd want.
Well, they would want to have the same tax rates that would be
right
for anything that is tethered.
Right, that's why I don't know what the criteria really would be for selecting them, if that makes sense.
Yeah, yes, now it's out of my, I'm trying to appease to a point both sides that I'm in favor
I'm not
of tethering.
saying it's good or bad. I just need to
know. No, I'm just trying to figure out, I guess on my own side, I'd like to see the tethering. But at the same time, if we limit it, I just don't want unlimited untethering. I have some concerns around the untethered from what we were hearing during the public hearings regarding some fail safes that may or may not be able to be in place as far as that goes. And I don't know. My hesitation is I'd rather not have unlimited untethered in the event that a fail safe doesn't work. And I'm not sure, maybe I'm just not clear. Maybe I should just go with what appears to be the majority report at this point. Representative Chiazzo, you're just laughing at me. That's not funny. Funny. You're new to this too. You're new to this too.
Yeah, either way, I think we just need to know how to choose the 3 untethered for drafting. I think it's.
Can I work on that and figure out? I mean, we're gonna have language review at some point.
Well, the problem is I've been directed, we're supposed to try and draft everything that we can this weekend,
So who normally does these RFPs that would be helpful to help write the RFP? And I realize Senator Lucchini is not in favor on this side, but maybe he has more information because he's been on this committee an awful long time to know where that stuff goes.
Yeah, Director Champion I don't see him in here, but I mean, I think we could do something like maybe like a financial suitability, number of other states that they operate in, things like that, if that works. Or
so I could take out kind of the criteria for licensure and make those, kind of model those. And then when you see the language review, I'll have drafted it and you can see it and see if you like it. Does that sound good?
That sounds great.
Okay, sorry. Okay, thank you. Thanks, everybody. So we also have, I'll let Janet keep taking notes for a while, but we still have those other 3 bills. If we want to dispose of those, we can do it. We'll just take just a minute to get the paperwork done.
I think I know how everyone voted which report, so thank you for the pause.
Okay. So I guess we can take the other ones, I guess one at a time, probably the cleanest way. So we'll open the hearing or the work session for LD 1404. So is there, is there a motion for Representative Chiazzo?
Thank you, Mr. Chair. I think we put all our eggs in the 1352 basket, so I'm prepared to move ought not to pass for LD 1404.
Can I ask for a pause on that? Sorry, I forgot something about the prior vote.
Sure.
So the prior vote, as you used 1352, which uses existing penalties, we don't need to go to criminal justice for a review, but you will need to go to judiciary for a Freedom of Access Act review. And it'll have to be somebody from the majority report to come with me. I know we now have a Judiciary Committee member, so that might be who comes with me.
I was going to nominate her. No, I'm
Yes, second.
I'm not on the report though. So.
But the things that will have to be reviewed are the confidentiality for the results of the fingerprint-based background check, which I know how to write that memo. I've written that memo several times before, but I don't know how to write what the justifications are for the confidentiality of the, there's another provision, I think it's the worrisome gambling activity. I'm not using the right phrase. And some information is submitted by the governing bodies to the director and has to be kept confidential. And so I would need some help maybe on what the justifications are for that, so I can write that memo up. I think they might want to do those as early as next Friday.
Okay, Representative Chiazzo.
Thank you, Mr. Chair. I obviously Representative McCrate is the idyllic person to do that, but hopefully Chairman Lucchini can help a little bit, because I think the body of that was mostly his stuff as well. So hopefully you'll be able to get a little bit of insight and guidance as to the best way to do it, even though he was on the minority report, because I know he's willing to work with all of us to get a best product possible out the door.
Love to.
That's a question. That's not a statement. That's a question.
Yeah. Yeah, we'll see. Depending on the time, I can help out, but I think probably Representative McCrate might be the best candidate being in the room at the same time. If you're good with that, Representative, because you may already be in there. You get, okay, thanks. And if not, I can fill in too. So, and I won't do anything funny. Okay, so I guess going back to 1404, did Representative Chiazzo, did you make a motion? Or okay, so we have a motion of ought not to pass. Do we have a second?
Second.
Seconded by Senator Hickman. Any further discussion? Seeing none, Deb, if you can please call the roll.
Certainly. We're voting on 1404. Senator Lucchini.
Yes.
Senator Hickman.
Yay.
Senator Farren. I'll circle back. Or is Senator Farren not on the call?
I think he may be on multiple committees. Yeah. So.
Okay. Representative Chiazzo.
Yes.
Representative McCrate.
Yes.
Representative Tuttle is absent. Representative Riley.
Yes.
Representative Supika.
Yes.
Representative Wood.
Yes.
Representative Kinney.
Yes.
Representative Harrington is absent. Representative Corey is absent. Representative Doloff is absent. So that's 9 yes, and 4 absent.
Thank you, Deb. And the absent members will be able to register their vote by Tuesday. Okay, next we have LD 1405, another sports betting bill. Do we have a motion?
Motion ought not to pass.
Okay, a motion of ought not to pass by Representative Supika. Is there a second?
Second.
Second.
Second by Representative Wood. Any discussion? Seeing none. Deb, can you please call the roll? The motion is ought not to pass.
Senator Lucchini,
Yes.
Senator Hickman,
Yay.
Senator Farren is absent. Representative Chiazzo,
Yes.
Representative McCrate,
Yes.
Representative Tuttle is absent. Representative Riley,
Yes.
Representative Supika,
Yes.
Representative Wood,
Yes.
Representative Kinney,
Yes.
Representative Harrington is absent. Representative Corey is absent. Representative Doloff is absent. That's 8 yes and 5 absent.
Great, thanks, Deb. Okay, next up, we have the last of the sports betting bills, which is LD 1527.
In regards to LD 15, and I move ought not to pass, Mr. Chair.
Okay, a motion about not to pass. Is there a second?
Second.
By Representative McCrate. Any further discussion? Seeing none. Deb, can you please call the roll?
One moment.
Yep, sorry, we're going quickly.
It's good.
It's rare.
Senator Lucchini,
Yes.
Senator Hickman,
Yay.
Senator Farren is absent. Representative Chiazzo,
Yes.
Representative McCrate,
Yes.
Representative Tuttle is absent. Representative Riley,
Yes.
Representative Supika,
Yes.
Representative Wood,
Yes.
Representative Kinney,
Yes.
Representative Harrington is absent. Representative Corey is absent. Representative Doloff is absent. So that's 8 yes, 5 absent.
Great, thank you, Deb. All right, so that takes care of those 4 bills. Next, we'll just give a minute to get ready to move on. We'll take up LD 554, an act to create gaming equity and fairness for the Native American tribes in Maine. And I do want to recognize, as we did earlier, we do have Chief Sabatis with us, as well as Chief Francis. That's all I can tell from the list. But welcome and thanks for being here. So we've, at the last work session, we kind of directed the tribes and the tribal attorneys to work with the AG's office and Janet, and they've done amazing work in such a short period of time to put together some amendment ideas that would make this work doable. And I just want to thank at the outset everybody's hard work on a short time frame. Put something together that will make this bill better for us as we potentially vote it, send it out to the floor. So thanks to everyone for their participation and time.
Did you want me to show you it now?
Yeah, please.
Trying to make sure I'm on the right file.
No.
You guys, when you're ready, you go quick. Okay, so this is the proposal from the tribal attorneys after, as Senator Lucchini said, speaking with the AG's office and myself on sort of ways that might help with the drafting to prevent challenges, maybe not prevent challenges, but strengthen the amendment. It's my understanding of how you wanted a proposal. So it would be based upon the amendment that was proposed by the 3 original tribes that were part of 554, and that was presented at the work session on the 20th. But it would add a provision to ensure that the Aroostook Band of Micmac is able to conduct all 3 classes of gaming to the same extent as the other tribes. And most likely that wouldn't be in the main implementing act because of the possible problems with that, but there would be a provision for them as well. There would be language confirming the jurisdiction and authority of the tribes over gaming operations on their respective territory and trust land. And this is because of the potential conflicts maybe within the main implementing act versus this proposal. But it would be drafted in a way that wouldn't offend any of the tribes, because there are some disputes about different sections of the law that may or may not be affected. So that wouldn't, it would be drafted in a way that wouldn't sort of weigh in on those disputes. The next part is that it would be written in a way that if a court were to find this act applying IGRA to the tribes ineffective as to any one tribe, nation, or band, then the act would remain effective as to the other tribes, nations, or bands. So they want to each respect the other's right to proceed under IGRA as far as tribal gaming on tribal territory is concerned, without having a decision against one tribe sort of strike it out for everyone. In addition, there would be, this is the belt and suspenders approach that was discussed at the last work session. Was that only yesterday? I can't remember. And this is where there would be a similar provision to everything that's been discussed before, but it would also be located outside of the main implementing act in case there's any dispute about the fact or about the authority to put this language within the main implementing act. There would also be language outside of the main implementing act doing all of the same things. So saying that gaming would occur under IGRA, that IGRA doesn't affect or preempt state law, including that if this is struck down for one tribe, it's not struck down for the other tribes, nations, or bands, and affirming the authority to have jurisdiction to adopt any laws or ordinances necessary to implement these provisions. And so then there, because it's the belt and suspenders approach, you think of it as all of these things would be effective immediately upon each tribe, nation, or band agreeing to it. So every tribe, nation, or band gets to decide separately for their own purposes whether they agree, and that agreement or disagreement won't affect the other tribes. And then there's a belt and suspenders approach, and each tribe, nation, or band, the validity of this act for each tribe, nation, or band doesn't affect the other tribes. So that's all of this top part. So the last bullet point talks about what happens if a court does say that IGRA can't apply in Maine, and therefore all of this top part is repealed for any one tribe, nation, or band, or combination thereof. What then happens? So the tribal proposal is not to leave sort of a vacuum, but instead to say that if IGRA can't be made applicable, then whatever affected tribe, nation, or band that applies to would be able to conduct Class 1 and Class 2 gaming under tribal laws and ordinances, as long as those laws and ordinances are at least as stringent as federal laws governing Class 1 and Class 2 gaming. So those federal laws would be IGRA and the implementing regulations. And so long as tribal health and safety laws at the gaming operations are at least as stringent as state health and safety laws. So that's the proposal.
Thank you, Janet. And remind me again, who was the AG involved in these discussions as well?
Yes, it wasn't, I mean, she's here, she can speak for herself, but it wasn't as if she said, yes, I agree or disagree to that. It was just a sort of a helping to understand possible ways to strengthen the amendment.
Okay. And I think we talked a little bit about severability and stuff, and I'm sorry I missed that earlier. But that is, I'm looking to see here, was that addressed?
Right, so
I see it now, yeah, thank you.
So there's two aspects of the severability argument. So the first that the tribes wanted to propose was that if any one of them is found to not be able to operate under IGRA, that wouldn't affect the other tribes, nations, or bands' rights to operate under IGRA. So that's sort of severability piece number one. Severability piece number two is the piece we talked about last time, which is if IGRA can't apply and we've said state law doesn't apply, then there would be a kind of vacuum. So all of this top part would go away if a court says that IGRA can't apply to that one federally recognized Indian tribe, and you would be down here in the backup provision for that one federally recognized Indian tribe. And if a court says it for another one, then they would drop down here to that backup provision as well.
Okay. And obviously this is coming right off the press. So have you had a chance to look at what the impacts are?
What type of impacts?
I was thinking more in terms of, is there anything that's going to be hung up with allowing the non, I don't want to use sanction, I don't know if that's the right word, but if somebody drops out or is not, one of the tribes is not approved, is there any concerns with allowing them to operate under Class 1 or Class 2 the way they're proposing here? I think they're already doing that to some extent, right?
So obviously you can ask others if I'm going to say this wrong, but the idea would not be that they would be operating Class 1 and Class 2 gaming under state law. So the rules about it has to be charitable gaming or only high stakes Beano on certain weekends and certain, you know, all of that stuff would not apply. It would be an IGRA-like scheme where the tribes can operate, you know, within their own decision-making process of whether they want to operate, but the rules would be that they have to have at least as stringent requirements for gaming that apply under IGRA regulations. And the health and safety laws would have to be at least as stringent as state law. But otherwise, so the only difference between this backup and the IGRA plan is that there isn't going to be approval of an ordinance by the National Indian Gaming Commission because IGRA won't apply. So it will be, instead, they're going to have their own laws that would satisfy an IGRA requirement, but there's not going to be a gaming commission that approves that ordinance, but anybody who disagrees can sue and say, you know, they shouldn't be allowed to operate because they're not meeting the requirements of the law. That's my understanding from our discussion yesterday, but I certainly welcome anyone who is in that discussion to correct me if I'm wrong. If you need me to stop sharing so you can see them, that's fine too.
Yeah, if you could, please, that would be great. Thank you. I apologize. I don't know who was actually in the discussion. So if there's somebody in the attendee room that was, I can't see who, I'm not sure who was actually participating from which side, but
Here.
Senator Hickman, sorry.
Oh, that's okay. Thank you. I would ask if we could please hear from Attorney Corey Hinton.
Sure.
Thank you.
Welcome, Mr. Hinton.
Thank you very much. Good afternoon.
Good afternoon. You guys were busy.
It was a good day, full of a lot of really constructive work, though.
Excellent, excellent. I guess I would ask, you know, if you concurred with, or if there's anything additional you wanted to add in addition to Janet's summary.
Sure, I would. Janet did a fine job. I think I would just add that this contingency structure that we're talking about, keep in mind, this is just the fallback. You know, so in theory, the authority for the tribes to conduct all class of gaming, to negotiate it. We have it up front. In this fallback scenario, I think it's important to note that in class 1 and class 2 gaming, the tribes, even though you wouldn't have that federal law overlay, the tribes would be doing this under their own laws. Federal law requires that tribes have an independent gaming agency within their governmental structure that must be created as a part of their tribal gaming law. And the tribe submitted, I believe, yesterday or the day before, examples of one example of a model gaming ordinance is what it's called. That would sort of set a baseline for what you could expect to see under tribal law passed in this fallback, or, theoretically, if before a fallback is necessary. So you'll see how a tribal gaming agency would need to operate. And the way those agencies work is very similar to the state gambling control board. And they work hand in hand with a federal agency. So if you don't have the federal agency overlay, you're still going to have that tribal gaming agency. And then it's important to note that the amendment would not provide for the conduct of class 3 gaming. Those large casinos are not contemplated here. The tribe's thought being that if there's a successful third-party challenge, the tribes would need to return to the legislature and work with the governor's office in the legislature to come up with an alternative plan. So just wanted to note that that is not addressed here purposefully, and it's not our intent to have a vacuum with respect to class 3 gaming. It's effectively, not contemplated in this fallback scenario.
Okay, thank you, Mr. Hinton. Any questions from the committee for Mr. Hinton or for Janet? Okay. Sorry, Senator Hickman. Sorry, Senator, you're on mute, sir.
Thank you. I do not have a question for Mr. Hinton. I do have a question for the Office of the Attorney General, Kim Petwarden. I've learned to say that correctly over the last 24 hours.
Let me grab, there she is. Yeah. Give her a second to beam in here. There we are. Welcome.
Hi, good morning, Representative Chiazzo, members of the committee.
Senator Hickman, I believe you had a question. Sorry.
Thank you. Good afternoon. I hope that you are doing well today, and thank you for being here. My question is, if this amendment goes into statute, is the Office of the Attorney General prepared to defend it against a lawsuit?
Well, certainly, the devil's always in the details. And so these are, proposed amendments. And so I think obviously the language will be important for how these things worked out. So one question that I still have is for the sort of like we've kind of been referring to this as a plan B. So plan A is IGRA applies. And then plan B is what happens if IGRA doesn't apply. And I think that's what Mr. Hinton was talking about with operating the equivalent of what would be class 1 and class 2 gaming. So my first question is whether or not that would be that statutory language would go in the implementing act, or if it would go in just under regular state statute. But as far as whether the Attorney General's office would defend the law, I don't think we can make a prediction as to that definitively. I mean, certainly, and also, I'm also not sure entirely that the AG's office would be involved. It seems more likely that the challenge would come from a third party. So, the AG's office might be involved or might not be. But, when that, I certainly have, based on some of the proposals that are in there, we would have more confidence in the law withstanding scrutiny than we did before the additional provisions that are proposed by the tribes.
Thank you. I appreciate that.
Any other questions for AG Petwarden? Okay, seeing none. Any other questions, comments from the committee? Janet.
I know I'm not on the committee, but I think AAG Pat Warden asked a good question, and I didn't know if Attorney Hinton wanted to answer it because that will help me draft it.
That's what I was gonna ask.
Kim, would you mind just restating the question so I can make sure I'm responding to it fully?
Sure. The question was whether the tribal proposal was to create the Plan B section, if IGRA doesn't apply, and such that, it's that fifth point on Janet's list where tribes would be operating the equivalent of Class 1 and Class 2 gaming under tribal ordinances. Is that a provision that would be in the Maine Implementing Act? So would that contingency be enacted into MIA, or would that contingency be in Title 8 in a different chapter of Title 30? I think that's important for the committee to know.
Right. Thank you, Kim. That's a good question. And my understanding has been that we're hoping that the point really of this belt and suspenders approach is that there would be the provisions that you've seen before you would also be included in a separate part of state statute, not within the MIA, so that they could essentially be the suspenders to pick up the pants if a court declares the MIA provisions not to be valid. So where specifically that's put into statute is something that, I think that Janet and the tribal attorneys and, I think Kim, we'll all be working to figure that out. But it was our intent that essentially this language appear in two parts of Maine's laws, the MIA and in a separate place.
So just so I understand, it sounds like we're talking about sort of two or perhaps three different concepts. The first is that there will be amendments to the Maine Implementing Act in order to make the Indian Gaming Regulatory Act apply in Maine. And then there will also be parallel provisions enacted into Maine statute. So essentially identical language from what was adopted into MIA will also appear in a separate statute under state law. And both of those statutes will become effective immediately, such that they could be, if there was a potential challenge, they could be evaluated at the same time within that lawsuit. So if, for example, the amendments to the Maine Implementing Act were not effective, then the court could then also look immediately to the other state statute and say, okay, do these provisions of this state law, does this allow the Indian Gaming Regulatory Act to apply in Maine? And then if that is not successful, my understanding of what's supposed to happen is that pursuant to the non-severability sort of provisions that will be written into the bill, all of those provisions with respect to the Indian Gaming Regulatory Act would be invalidated, so that if a court says no good under the Implementing Act and also no good under this other chapter of state law, both of those sections would be invalidated. And then the backup is what Attorney Hinton is describing as the Class 1, Class 2. So it would be the equivalent of Class 1 and Class 2 gaming pursuant to tribal ordinances, only if both of those two things don't pan out, right? So Plan A is IGRA on two different avenues, and Plan B is equivalent of Class 1 and Class 2 gaming. But those other provisions with respect to IGRA would be invalidated and repealed. Am I explaining that correctly?
That's well stated, Kim. Yes.
Okay, great.
Are you good, Janet? Sorry, Janet, you're on mute.
Yes, I was glad she explained that much better than I did. And then the only thing I would add is what we just agreed is that the final thing that would be left if it had to get to that because of a court decision would be outside of the Maine Implementing Act. And that's the only other thing to add.
Okay.
I just want to add one slight, if I could, perhaps just one slight tweak to one of the bullet points that were presented by Janet and by the attorneys with respect to, there was a bullet point about strengthening the language of jurisdiction and and authority. I think maybe we can just add a small piece in there and correct for, account for other potential inconsistencies with the rest of the implementing act. I just want to be able to make sure that in case there is some other small amendment that might need to be added in order to effectuate what the tribal proposal is, that there is an opportunity to do that without having to go outside a language review process.
I would fully support that.
Okay, thank you, Mr. Hinton. Any concerns from the committee? I can't see everybody, sorry. There we go. Senator Hickman.
Thank you, Mr. Chair. I don't have any concerns. I just am honored to be able to make the motion ought to pass as amended on LD, what is it?
554.
554. Thank you. As
second.
Got lots of seconds.
Maybe we can let Senator Hickman finish.
No. We want in.
The amendment as proposed yesterday and today, with all of the different nuances and housekeeping bill, belt suspenders and everything else.
And the kitchen sink, everything, whatever's there, right? Perfect. And Representative Riley, I think I'll give you the second. I think I heard you jump in there too. So my apologies if I'm wrong there.
Don't forget the rakes and the garden hose too. Thank you.
All right, so motion on the floor is ought to pass as amended, presented by Senator Hickman and seconded by Representative Riley. Any discussion or debate? Representative McCray.
Thank you, Mr. Chair. Just want to echo that it's an honor and long overdue. Thanks.
Concur, definitely concur. Any other questions or comments from the committee? All right, seeing none, then Deb, if you would please call the roll. Yeah, let me count, make sure we have enough. 1, 2, 3, 7. Yeah, we're good. We're good.
We're voting on LD 554. The motion is ought to pass as amended. Senator Lucchini.
Yes.
Senator Hickman.
Yay.
Senator Farren is absent. Representative Chiazzo.
Yes.
Representative McCrate.
Yes.
Representative Tuttle is absent. Representative Riley.
Yes.
Representative Supika.
Yay.
Representative Wood.
Yes.
Representative Kinney is not on the call. Representative Harrington is absent. Representative Corey is absent. Representative Doloff is absent. So that's 1, 2, 3, 4, 7 yes votes and 6 absent.
Thank you, Deb. So the motion ought to pass as amended is unanimous of those present. The 6 absentees will have until noon, I believe, Tuesday, to log their votes in.
My only request is to have affirmative authorization, because it's otherwise confidential, to work with tribal attorneys and AAG Pat Warden in the drafting.
Yes, I'm comfortable giving that authorization, please. Yes.
Thank you.
I don't think there's any objection from the committee, but if there are, speak now. Okay.
Yeah, and thanks to everyone for your quick work over the last 24 hours. It's great.
Yeah. Very, very impressive. All right, so that concludes the work session for LD 554. Senator Lucchini, if you want to step back in the driver's seat, I will turn it over to you, sir.
Okay. All right, thanks everybody for your help on that bill. So now we'll move to the next on the list, LD 1518. I think we'll do this and then we'll take a brief break again to caucus probably, and then come back for the final 3 bills. So LD 1518, an act to support Maine's tasting rooms and restaurants during the COVID-19 pandemic.
I'm hurrying.
Give it a minute to switch around. Sorry, we're bouncing everywhere. So.
Just 1 second, sorry. Is that big enough for you to read?
That looks good. Yep.
That was a stalling tactic. So LD 1518, as the senator said, is an act to support Maine's tasting rooms and restaurants during the COVID-19 pandemic. It's an emergency measure that would make the following changes to Maine liquor laws. First, it would establish new exceptions to the three-tier system of liquor distribution that authorize each licensed in-state liquor manufacturer to have a financial interest in a single licensed retail establishment, and each licensed retail establishment to have a financial interest in a single in-state licensed manufacturer. In addition, there's a second portion of the bill about suspending food sales requirements that the sponsor did propose at the public hearing, removing from the bill because you already enacted legislation that accomplishes the same goal. So I'm happy to read through it if you want, but that's my shorthand for the moment. So as far as the provision of the bill that talks about new exceptions to the three-tier system of liquor distribution, just to remind you, we did have a presentation earlier this session on the three-tier system, and I linked the document here. So anyone who wants to take a look at it can. But under that system, a licensed in-state manufacturer of liquor and an out-of-state manufacturer that has a certificate of approval to export its products to Maine are prohibited from having a direct or indirect financial interest in any licensed on-premises or off-premises retailer of liquor in Maine. There are some exceptions to that prohibition. Oh, and I should mention that the reverse is also true. The licensed retailers are prohibited from having the interests in the manufacturers as well. So there is a minor investment exception where a licensed in-state manufacturer or out-of-state manufacturer that has a certificate of approval can have a minor investment in up to 1% of the securities of the licensed in-state retailer and vice versa. There are allowances in the Maine manufacturer statute that do allow all licensed Maine manufacturers at their production facilities to sell their products directly to consumers for off-premises consumption, including through the bill you recently enacted to sell those spirits as part of an approved cocktail in an approved sealed container. In addition, more relevantly to this bill, a small winery or small distillery may obtain a license to sell its products for off-premises consumption at up to 2 additional locations other than a manufacturing facility. In addition, for on-premises sales, the licensed Maine manufacturers can sell their products as samples at their production facility, and if 714 is enacted, they would also be able to sell their products, samples of their products mixed in a cocktail for on-premises consumption. But again, more relevantly to this bill, each licensed Maine manufacturer can obtain 1 on-premise retail license for each of its licensed production facilities. The same person or persons must hold a controlling interest in both the licensed manufacturing facility and the on-premises retail establishment, and it may be located either on the premises of the production facility or at a separate location. There was some mention about federal tied house restrictions, which I'm happy to get into, but I would point out that under federal law, it's not like the three-tier system where a manufacturer can't own an interest in a retailer. The problem is if they have that interest and then through that interest, they attempt to directly or indirectly induce the retailer to purchase products from that manufacturer or wholesaler to the exclusion of products sold by other manufacturers or wholesalers. So the tied house restrictions under federal law are about unfair trade practices. So it's not just about ownership requirements, it's about those ownerships being associated with unfair trade practices. So there are some technical issues with this bill. First of all, its location. I might move it to 1355A, which is the licensed Maine manufacturer provision, to put it in there where all the other exceptions for the three-tier system that apply to just Maine manufacturers are located. But that's up to you. You may also want to clarify some of the following issues, especially given the testimony at the hearing. So The way that the bill is drafted, any one manufacturer may only have any interest in any one retail licensee, and that is not the way that the testimony seemed to talk about it. So, and also it doesn't distinguish between on-premises and off-premises retailers. So the first question is, may the main manufacturer obtain an interest in an off-premises retailer, for example, a grocery store, or may it only obtain an interest in an on-premises retailer, for example, a bowling alley, which was the example given at the hearing. If the main manufacturer has the on-premises retail license that it is already allowed under current law at sort of, for example, if you're a brewery, if you have a restaurant associated with your brewery, are you prohibited from having an interest in any other retail license? So it was my understanding at the hearing that there is perhaps a brewery that has an on-premises retail license, but they also want to have a bowling alley. That would not be allowed under the bill as drafted because it only allows one retail license. Also, the question would be, is the bill intended to limit a small winery or small distillery to only obtaining one additional licensed location at which it may sell its products for off-premises consumption? Because if you remember, that's a current exception to the 3-tier prohibition. So if you're a small winery or small distillery, you not only can sell your products for off-premises consumption at your manufacturing facility, but you may obtain an additional license and sell it at another location. It's not clear to me if that additional license is considered a retail license, because it's arguable. You might want to clarify that. In addition, if you read the bill as drafted, it actually would prohibit the small winery or small distillery that does have that license for off-premises consumption at another location. It would prohibit them from getting their one on-premises license because they're only allowed to have one retail license under the bill. So I didn't know if it was intended to force them to choose between those two options. So I don't think that was the intent based on the testimony, but that is how the bill is drafted.
Okay, thank you, Janet. Any questions from the committee on Janet's analysis? And we have Director Minio as well, if we need to ask him for some clarifications. I think he's in the attendee room as well. Any discussion? Chairman Lucchini.
Thank you, Mr. Chair, and thank you, Janet, for that. I think while it's well-intentioned, I think the industry was pretty unanimous in opposition to this. So I would make a motion of ought not to pass.
Okay, motion ought not to pass by Senator Lucchini. Is there a second? Representative Wood?
Second.
Okay. Did you have a question, Representative Wood?
Yes, Mr. Chair, I did have a question. And if Director Minio is there, if he could come in for this question about, I think that he said and others said that there is a path already that exists for owners to be able to do what they want to do. I just wanted to verify that my notes were correct.
I'm sorry, Representative. Yeah, I was being transitioned in when you were asking your question. I apologize. Would you mind repeating it, please?
That's okay. We do that on purpose.
Oh, you're trying to keep me on my toes.
Try to catch you. I have in my notes from back in April that there is already a path that business owners can do this.
Yeah, there's a path. It's the one that I mentioned in my testimony. Chief Inspector Larry Sanborn has offered this on a number of occasions to manufacturers. It's where you're able to actually set up a brewing operation in the other entity that you own or wish to own, and that in itself then would be it would maintain the one-to-one between manufacturer and the other business. That I think that's the path you're probably remembering.
Right.
But that, by the way, was offered, and Mr. Sanborn did consult and counsel the manufacturer that we're referring to in northern Maine, and they were not interested.
Okay, thank you.
Yes, ma'am.
Thank
Thank
you.
you.
So, Mr.
Okay.
Chair, if I could, I just think by not passing this bill, it's not saying no, it's just saying there is an existing way to make this happen. So I support the motion not to pass.
Okay, thank you, Representative Wood. And Director Minio, are there any, how can I say this? Are there like minimum production requirements or something in order for them to be considered a manufacturing facility? Meaning, could they have a small batch there instead of a giant, big production with copper kettles and everything else like that?
Yeah, there are minimum requirements. It's it's not going to be. You can't make like a home brew, if you will. In a 5-gallon bucket. That's certainly not going to pass the rate-based test. Yes.
Okay. All right. Thank you. Representative Wood, did you have a follow-up? Okay. Any questions for Director Minio while we have him here? Okay, seeing none. Thank you, Director, for being here this afternoon. Motion on the floor is ought not to pass. It's moved by Chairman Lucchini, seconded by Representative Wood. If there are no other questions, then Karen's back. No, I don't think it's Karen's back. Sorry, Deb. I see Karen's screen with no video, so she might be just recording. So, Deb, if you would please call the roll.
Certainly. Senator Lucchini.
Yes.
Senator Hickman. Stepped out. Senator Farren is absent. Representative Chiazzo.
Yes.
Representative McCrate.
Yes.
Representative Tuttle is absent. Representative Riley.
Yes.
Representative Supika.
Yes.
Representative Wood.
Yes.
Representative Kinney.
Too much stuff on my keyboard. Yes.
Thank you. Representative Harrington is absent. Representative Corey.
Hi, Deb. Yes.
Hi. Representative Doloff is absent. That's 9 yes and 4 no. I mean, sorry, 4 absent.
Mr. Chair.
1, 2, 3, 4, 5.
Oh, and we do have Senator Hickman back.
Yep. Senator Hickman.
Yay.
Thank you. So now it's 9 yes and 4 absent. I was counting you ahead of time.
Okay, so the motion ought not to pass prevails. The 4 absentees will have until noon on Tuesday to record their vote. And that closes the work session on LD 1518. We are scheduled to run the next 3 bills at 2 o'clock, but I think it would probably make sense for us to take a break and do some caucusing, because I think this is also an equally complex issue. So I think it'd probably be good for us to spend some time talking about it amongst ourselves. So I will defer to Chairman Lucchini what you think an appropriate amount of time is.
Yeah, thank you, Mr. Chair. I think people probably want to get some lunch too, because we haven't really stopped since the morning. So we may want to combine caucusing and lunch, and whatever each side thinks is 2:45 good, or enough time to eat and come back. Does that work?
Seeing no objection, then we will be in recess until 2:45. Oh, Janet. Oh, sorry, Janet. Janet.
I'm just waving.
Oh, bye. Okay, then we are in recess until 2:45. Thank you, folks.
Craig, did you come over to the building or something?
All right, folks, thank you for your patience. We're just waiting for caucuses to
Linda,
wrap
it's
up and
Jay
people
McCray.
to get back in.
I got your phone.
Hey, Sam, just to, if you're on there, just to give you a heads up, we'll probably be, when we get everybody in a quorum, we'll probably be starting up with LD 882, just so you know. So
Sounds good.
You don't have to fish around too much.
Perfect.
Okay, I think we just need one more camera to have a quorum to start up again. Perfect. Okay, thanks everybody. We're back again to deal with the remaining 3 bills on our agenda for today: LD 882, LD 1319, and LD 1242. We'll take those. We're taking them in that order. So Sam, if you wanted to just give us a little refresher on 882, I think we may have already done the analysis on this, but just give us a little refresher if you would, please.
Yeah, absolutely. Let me here. I'm always having trouble finding the window. Let me pull up the bill analysis, and I can just run through the summary again and ask anyone if there are any questions, if that works. There it is. All right, can everybody see that?
Yes.
Yeah, and let me magnify it a little. All right, as the committee will recall, this is LD 882, an act to amend the Maine Medical Use of Marijuana Act. And this bill makes the following changes to the Maine Medical Use of Marijuana Act. It authorizes the Department of Administrative and Financial Services to place an administrative hold on marijuana plants and harvested marijuana, or impose an administrative hold on certain registry identification card holders and registration certificate holders, to permanently revoke registry identification cards and registration certificates issued by the department, and to assess fines for misconduct by a registered caregiver, retail store, dispensary, manufacturing facility, or person authorized to engage in marijuana extraction using inherently hazardous substances up to $10,000. And it authorizes the department to assess fines for misconduct by registered caregivers or assistants or authorized agents of a registered caregiver, caregiver retail store, dispensary, manufacturing facility, or person authorized to engage in marijuana extraction using inherently hazardous substances up to $2,000. And if I remember right, I would just want to scroll down to the bottom here. The technical, yes, the one big kind of thing I had highlighted for this committee, I guess it's not that big, but in section 3 of the bill, it has the language regarding that the fines were in addition to any other penalties that may be applicable by law. And I had noted for the committee that this is generally the case in statute. And if we have it here, but not other places, it could imply that that's not true in other cases. So I might recommend altering that language to make it consistent with how we normally deal with penalty provisions. And does anybody have any questions?
Thanks, Sam. I don't know, could you take the screen off there so I can only see like four boxes. There we go, perfect. Any questions for Sam? Any discussion, debate? Chairman Lucchini.
Thank you. Thank you, Mr. Chair. I think personally, I'm not ready to move ahead with this legislation as written. I think we've heard from the industry. They put together that document that kind of outlines some of their suggestions. I think much like we did with the bill to have testing, I just don't think we're ready to quite go there yet. So my proposal for this, rather than pass it or kill it or something, would be something we talked to the industry and heard from them about, that they want to have a bigger seat at the table. So we could turn this into a resolve directing OMP to meet with a broad group of stakeholders within the medical community as well as larger as well. And the goal would be for them to just discuss basically everything. That 18-page document was a great guideline of some of the things that need to talk, but I think just generally to talk about the status of the industry, based on how it's doing, changes people would like to see, and concerns. So I think directing OMP to work with everybody would be the strongest way to also make sure that it does happen. So if people are good with that, I'd be happy to make that as a motion. I think that would help because, the combative kind of relationship between the regulator and the industry is not going to be healthy for anybody. So we want to make sure that people have a seat at the table, they have time to work things out. And then I'd have OMP report back to us in January and give us the authority to report out legislation based on the findings.
So just to be clear, Senator, you would strike everything that's currently in 882 and replace it with the resolve. Would it be specific just to talk about fines, or would it be just to talk about outstanding issues? Outstanding issues. Okay. Okay. Representative Corey, did you have a question?
No, I was just going to ask if it was going to authorize us to report out a bill, but it sounds like Senator Lucchini eventually got around to that. So,
yeah.
Okay, Chairman Lucchini.
Yeah, and that's kind of the thing. I'd want OMP to report back on the group's findings and how everybody, if they came to conclusions, if they didn't, give us a report back, and then give us the authority to report legislation that we could potentially use to overhaul a lot of things within the statute. So if people are good, I can put that in a motion of ought to pass as amended.
Any Representative Corey?
Has the department been consulted on this at all, or?
Chairman Lucchini.
I haven't, but we can bring them in if you want. I think they knew that I kind of was hoping this would happen, but I don't think they knew I was going to do it this way through this bill. But we can. I'm happy to bring them in if people want.
Okay, thank you.
Yeah, I just brought in Director Gunderson if you wanted to ask his thoughts on it. Just a reminder, I mean, it is our bill, so we can we don't necessarily need his permission, but it might be nice to let him know what's happening a little bit. So thank you, Director Gunderson. Welcome. Are you you heard what Senator Lucchini is proposing? Would the department have any concerns or reservations about a resolve like that?
If that's what we're asked to do and directed by the legislature, we'll obviously happily do it and meet with the stakeholders to move forward. I will just say that we have been asking since OMP has been established for some of this authority and administrative tools to help enforce the law and regulations. So obviously we would prefer that the bill pass as it is, but if this is the direction that we're going, then we're happy to have those conversations with stakeholders.
Okay, thank you, Director Gunderson. Any questions from the committee? Representative Corey.
Senator Lucchini, did you make a motion?
Yeah, sorry, I kind of made it weird, strangely, but yeah, I'd make a motion about to pass.
Second that. It's seconded.
All right. Any other directors for questions for the director? Okay, let me, thank you, Director Gunderson. Let me move him back out. Okay, so a motion on the floor is ought to pass as amended, made by Senator Lucchini, seconded by Representative Corey. Any further debate or discussion? Okay, seeing none. Karen, when you're ready, please welcome back. Please call the roll.
Thank you. Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. Representative Kinney, absent. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff. Representative Dolliff, absent. 9 in favor of the motion, 0 opposed to the motion, and 4 members absent, Mr. Chair.
Thank you, Karen. The motion ought to pass as amended is successful by unanimous vote of those present. Absentees will have until noon on Tuesday to register their vote. Sam, do you need anything from Chairman Lucchini, in terms of you'll probably need the resolve message or language, right?
I believe I have enough direction based on the conversation, but I'll follow up if I need more clarity.
Okay. Excellent, excellent. All right. If you're ready then, or when you're ready, I should say, can we move on to LD 1319, please?
No problem. Would you like me to go through the summary of this again as well?
Yeah, if you just hit the highlights for us again. I mean, we've had a lot of time to work through this. I just want to make sure we reset the memories again a little bit.
Absolutely. So as the committee will recall, I did the bill analysis for 1242 and 1319 on the same document, just because they are, similar in a number of ways. LD 1319 is an act regarding registered dispensaries and rules under the Maine Medical Use of Marijuana Act and the definition of resident in the Marijuana Legalization Act. This bill provides that the Department of Administrative and Financial Services may not issue more than 14 marijuana dispensary registration certificates. It also provides that the Department of Administrative and Financial Services Office of Marijuana Policy may not adopt rules governing the medical use of marijuana until December 31st, 2023. And that beginning December 31st, 2023, the Office of Marijuana Policy may adopt rules governing the medical use of marijuana only if the office, using existing resources and before the adoption of those rules, conducts studies on the economic impact of the rules and how the rules would affect the access of patients to marijuana for medical use. And the bill also extends the repeal date of a portion of the definition of resident in the Marijuana Legalization Act from June 1st, 2021 to June 1st, 2025. And I believe one of the notes I had for the committee on this one is just that if you were to move forward with this, with the prohibition on adopting rules before December 31st, 2023, 1319 does not indicate what happens to the current rules. The language kind of makes it sound like the current rules, and that is the ones that have been in place since 2018, not just the ones that are being developed, would be wiped out. So 1242 had language addressing what the current rules would be, during the interim process. So I just wanted to note that for the committee. If you move forward with this, you might want to clarify which rules apply until the moratorium's over.
Perfect. Thanks, Sam. Any questions on the analysis review? Okay, Chairman Lucchini.
Sure. Thank you, Mr. Chair. So I know previously I had put an amendment for LD 1242 out, but in talking with people in the industry and others, they felt it would be better to put it onto this bill and leave the other one for the next vote. So I'm happy to do that. So I don't know, Sam, do you have the amendment that I had kind of offered prior? If people are interested, we can go through it. It's kind of like the rule change amendment.
Yeah, would you like me to pull it up and read through each of the bullet points again, or just pull it up?
I think just pull it up and then I can explain, because I think I'll make just a quick change. I also want an addition after meeting with more people.
Okay. And I believe that addition's already on the list.
Cool.
So apologies if I got ahead of your intentions there.
No, thanks. I called you to not surprise you. Yeah, thank you. Yeah, can you show or highlight that or explain it just quickly so people understand? Yeah.
Would you like me to talk about it, or do you want to?
Yeah, if you're good with it, yeah.
Yeah. So the current proposed draft rules in section 6.2.2 basically lay out requirements for like how caregivers, like what for caregivers as business entities and what their structure of their business looks like. And this, the direction here would be to remove those requirements. And if the committee's interested, I can talk a little bit more about what the statute says. And I have the section of the rule ready to pull up too, if you want to have that on screen as well.
Thanks, Sam. I think that's good. We just wanted that portion of the rule. I know we'd heard from people in business in the community that felt it was more stronger than current law. So I think striking it from the rule and letting the law stand for itself is kind of my preference on this. If people are good with that, then I just wanted to throw that on the list of changes. We're trying to pick up as many issues as people have identified to try to clean it up. So that's the thought process there. Thanks, Sam.
And just to be clear for the committee, it's the amendment's going to go on to LD 1319, not 1242, like it is at the top. And I assume, again, is this a situation where we're going to strike and replace 1319 with this?
Yeah, that would be my intention. I mean, I haven't made a motion yet. I don't want to cut off the date or anything. So yeah, I'm happy to put this on. And if people need a refresher of what's in it, we can certainly do that too.
Representative McCray.
Thank you, Mr. Chair. A question for Chairman Lucchini. Could you just repeat that change that you're adding to this? I spaced out.
Yeah, sorry. I know you're in multiple committees at once. So thank you, Mr. Chair. Sorry to butt in.
No, go ahead.
Yeah, so basically it would remove the portions of the rule related to business structure requirements, which I think is 6.2, where I think essentially it says that people have to be, your company has to be the sole equity owner. So we just, where it was unclear, I think if that is directly in line with statute, I felt it'd be good just to cut that out of the rule and let the law stand on its own. And that was one that I just heard from a bunch of people in the industry recently, so I wanted to make sure we threw that in there as well.
Okay. Thank you, Chairman Lucchini. Any other questions, comments? Chairman Lucchini.
Thanks. Sorry, and just one more thing. You know, that's and part of the reason why I wanted to 882 to have everybody meet is that people can talk about these issues and then can bring it back. And that's partly why in this we delay the track and trace, because it appears that's the most controversial piece from everybody that I've spoken to. So that's why I've kind of delayed that implementation. And if people are able to come to agreement, that can be certainly part of the discussion with OMP over the summer. Then we can reevaluate in January. So that's kind of the proposal and that I came up with.
Okay. Thank you, Chairman Lucchini. Any questions or comments? So I guess sorry, Representative Corey, go ahead.
Thank you. So as I think I said in the last time we met on this, that, I understand sort of the interest in sort of putting a safety valve, in place, if that's what we're calling it. I'm just concerned that a safety valve, sort of creates a situation where, this is adopted when we really haven't had a chance to, look at all the rules or, and I understand sort of the good nature of this and trying to look at the things that people have talked most about, but I know that there's many other sort of concerns people have. So I'll likely be putting a minority report together on this, but I think if there's a valve that makes it through somehow and then the other bill becomes irrelevant. So cool, but I do appreciate the work that you're trying to do, Senator Lucchini.
Thank you, Representative Corey. Any other questions, comments? All right, I guess I'll add my 2 cents. I mean, I think, I think this coupled with the stakeholder meeting that will happen, I think takes into account a lot of what we heard from people in the industry about wanting a seat at the table. I think the compromise in putting some of these adjustments in place is important, because if, again, we've heard it a couple different times, if we fail to act, the concern would be that OMP's rules would go in entirely as is, and I'm not sure if anybody's really comfortable with that. So I think this is in my opinion, this is a great compromise. It gets some of the rules in place, maybe not the ones that everybody wanted or didn't want, but it does some act, and it also gives us a venue to look at and evaluate before making any other decisions or issues that go through as well. So, Senator Hickman.
Thank you, Mr. Chair. I just realized that I have, I told my colleagues I would be supporting this bill, this amendment. So I just want to not surprise and say that I will have a minority report on this bill, but I do want to support the effort of the compromise. I guess I just can't vote for a bill that allows for metric to be in the law, to be used in the medical program, because the privacy concerns take precedent to me over anything else. Thank you.
Okay, thank you, Senator Hickman. Senator Farren.
Thank you, Mr. Chair. I guess a little confused. I hear what Senator Hickman's concern is, and I thought the amendment by the Senate chair kind of address some of those concerns as far as the confidentiality of the patients. Is there still a disconnect there? Because I share some of the same concerns, but I had in my mind that we were addressing some of those with this amendment, and maybe it just doesn't go far enough, but I'd just like to understand that detail just a little bit more.
Thank you, Senator Farren. Chairman Lucchini, did you want to respond to that?
Sure. So I tried to address the track and trace things in a few ways, but I know it's probably not far enough out for some people, and I totally understand. So in this amendment, I had a statutory provision that would say that you can't have the names of people, like the identifying information, and it directs OMP to exempt small caregivers from the track and trace system, which will likely have to be statutory, just the way that it falls, I think, Sam, if that's right. And so that would create a way that we could exempt some of the smallest caregivers, but it doesn't establish exactly how. That's something the department would have to figure out. And then kind of as the last measure, I had extended that the department can't enforce anything on track and trace for retail storefronts until January of 2021, and for home-based caregivers until June of 2022. So it puts it out a year before this could be enforced on home-based caregivers. So if they wanted to start implementing it, they could. This would be rolled out with dispensaries first, but it pushes it out. And then if there is a solution that's found from people, then they could potentially change the law in January when we come back. I don't know if that answers.
Thank you, Senator Farren. Senator Hickman.
Yes, thank you, Mr. Chair. So in the primer that I received in the last few days, the concern that I remain to have, even though, yes, this is a step in the right direction to not include identifying information in the portal, but the way that this particular system the state has contracted with works is that when you have to, your trip ticket becomes digital. It becomes reported into the system, which means if you deliver cannabis to a patient, you have to let the system know where you're dropping it off. So even if your name and your identity isn't there by name, where you live is in the system. And that means that people will know where the patient lives in a system that is privately held by a third party. And I have no idea what's going to happen with that data. So that's still my concern, because that system requires that that's a part of the reporting mechanism. There's a location of where the patient lives. I hope that clarifies for you, Senator, why I'm still a little reticent about this particular system being used to track and trace medical cannabis.
Thank you, Senator Hickman. Any other question or discussion? Okay, I don't know if we have a motion on the floor. I don't think we have one yet. So I'd be willing to entertain one. Somebody wanted to make one? Chairman Lucchini.
Sure. Thank you, Mr. Chair. Yeah, I'd be willing to make a motion of to pass as amended with this amendment that I put forward with the changes.
Second.
Second by, okay, so the motion is ought to pass as amended with Senator Lucchini's amendment. Moved by Senator Lucchini, seconded by Representative Wood. Any further debate or discussion? Senator Hickman.
Yeah, I just wanted to say, I know that the Senate chair has received lots of emails, phone calls, and has had thousands of meetings. Maybe that's an exaggeration, but I bet it doesn't feel like it. So any effort to try to appease all the different points of view that he heard with different styles of people putting them forward, I applaud the effort. And like I said, while I won't necessarily vote for the amendment as is because of that privacy concern, you know, it's better than nothing. And I just want to say that on the record and applaud him for his work to try to satisfy everybody. Thank you.
Thank you. I'm sorry. Thanks, Senator Hickman. I know it's imperfect, but hopefully a step in the right direction.
Okay, any other comments? All right, seeing none. Karen, when you're ready, please call the roll.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Nay.
Senator Hickman, nay. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
No.
Representative Supika, no. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. Representative Kinney, absent. Representative Harrington. Representative Harrington, absent. Representative Corey.
No.
Representative Corey, no. Representative Dolliff. Representative Dolliff, absent. 6 in favor of the motion, 3 opposed to the motion, and 4 members absent, Mr. Chair.
Thank you, Karen. So the motion before us ought to pass as amended passes with majority present. The 4 absentees have until noon on Tuesday to register their votes.
Chair, the minority report from the minority, please.
Thank you, Karen, as always. I think Senator Hickman, did you want to start with a minority report?
I will defer to Representative Corey.
Okay, Representative Corey, your minority report.
Thank you. So I'm going to do an ought to pass as amended. And what my plan here is to do essentially what I'm going to be doing in LD 1242, so that we can save a little bit of work for the analyst. If we were to skip down to the summary of LD 1242, I'd like to, make it so that, the rules ending up governing, medical use of marijuana go from routine technical to major substantive. It, asks that essentially part 2, that they convene, and before adopting, those rules passed, that were made after February 1, 2018. Yep, to establish a process to include caregivers, registered caregivers, and patients, and physicians, and certified nurse practitioners with significant knowledge and experience certifying patient under the law. in the development of these rules that there has to be a consult, with these people. One thing I would like to add to that, and at least, pulling from LD 1319, that we're also going to be studying the economic impact of the rules and how the rules would affect the access of patients to marijuana or medical use. In part 4 or part 3, it talks about the department developing a process to retain a consultant hired to advise on rule changes related to good laws governing medical use of marijuana and report to the development of this process no later than September 1, 2021, and shall report on any subsequent changes to this process to the joint standing committee of the legislature having jurisdiction over, and it says health and human service matters here. I kind of feel like where this is with VLA right now, it probably, needs to, be this committee, since we're the ones sort of opting to look at these rules. So I don't think we want to necessarily look at health and human service matters, although I'd definitely be willing to hear from the other people that plan on being on my report if they do. I wanted to get rid of these third-party audits because nobody, again, is able to really describe how that works or what it's supposed to be. And lastly, what I want to do is put a hold essentially on any kind of a track and trace system. I don't know if we would actually say metric in the law. I don't believe we would, just an electronic portal until after the economic impacts have been looked at for, caregiver size based businesses. And I'd certainly like to hear from anybody that I may be on my minority report with at this point.
Thank you, Representative Corey, for that thorough minority report, to say the least. Any concerns from Representative Supika or Senator Hickman, your hand is raised.
Yes, thank you. So if I'm clear, it sounds like the minority report is LD 1242 with one tweak, or is it L 1242 as written?
It's 1242 with just a couple of tweaks. Those tweaks would be that with regard to the report back to our committee, to look at the rules that were made, that they're also looking at sort of the economic impact of the rules and how this has to do with, patient access to their medicine. Another, tweak would be sort of that we're going to put the track and trace system on hold until after that sort of economic analysis, has been done. And then third, it talks about how, the changes and, the report back is actually to the committee that has jurisdiction over health and human services matters. But I think that where, this seems to be under our purview right now, it probably needs to, be reported back to VLA.
Is there a way to draft it so that it says report back to the committee that has jurisdiction over the Maine Medical Use of Marijuana Act? Because who knows if this committee will always have a jurisdiction over that. Is that something that could it be drafted that way, Mr. Prower? I guess is my question.
That's acceptable to me, so.
Yeah, I think we can certainly draft it that way. I think that's precisely the reason we usually say like jurisdiction over such and such matters rather than name the committee, because things move around. Yeah.
And then the other question that I have about the language about putting it on hold, 1242 just strikes that provision from the law entirely. And so I'm not sure how not to strike that provision of the law but leave it and then put it on hold, I guess, until an economic impact study is done. I guess for me, if I were to join this report, I would want to just see that language struck, because if it has to go back in with something else on it, or at least strike the part of the law that requires the second and third paragraph of B, so that the burden of who's paying for it isn't on the caregivers or anyone in the industry. That is just something that the state pays for, that is used to have the stuff reported to it, whether it's metric or not, which I don't agree with metric, but that's not the issue in statute. So Representative Corey, can you tell me if you'd be satisfied leaving that out of the law completely? Or
my concern, at least, is sort of the economic, impact on such a system, and it may not even be the price of the system plus the tags, though I see that as being a cost, because that was a discussion that obviously was had when this was adopted originally. But I see that, for a very small, caregiver, they may not have the staffing and the resources to, have any kind of scale, in order to do this work. So I think that economic impact may not just be the cost of the software and the tags, but the actual human resources needed to implement, such a system.
Okay, so how do we draft language to put that on hold until an economic impact study is done? I guess we can figure that out later, but
I think that we can say that. Oh, Sam's got his hand up, so maybe he has an idea.
I didn't want to interrupt. I can think of a number of ways, and perhaps maybe in committee is not the best place to workshop it, but one thing that comes to the top of my head is we could put in the statute a provision that says this section may not be enforced or may not take effect until such and such date. And that could be a date after which you get the report back from the committee and have a chance to submit new legislation that could either change the provision or strike it entirely or leave it in. So that's one way. And there may be other more clean ways too, but I'm pretty sure we can do something like that.
Okay, great. Then we can talk about that after. I just know that it needs to be clear in the record what we're attempting to do.
That works for me. That
is an amendment, I will join it.
Okay.
Representative Supika, would you like to add something to any of that?
No, I thoroughly enjoyed getting to hear that conversation in this public meeting. It was probably, I enjoyed that. So yes, I am in support of it as well. So thank you.
Okay, excellent. Okay, I think we're finished with 1319, and I know Sam's got to take some notes and stuff, so we'll give him some time to catch up.
I think I've got him.
You're good? Okay. All right. Then when you are ready, sir, we can move on to 1242, please.
All right, let me pull this back up. All right. Oh, getting attacked by my cat in the middle of a work session. People who've been in a committee with me in transportation know this is a common occurrence. So LD 1242 is an act to ensure the appropriate oversight of Maine's medical marijuana program. And I'm going to run through the bullet points, even though there's quite a few, just to make sure everyone's on the same page, especially just after the last conversation. So this bill changes the designation of rules governing the medical use of marijuana from routine technical to major substantive. It provides that the Department of Administrative and Financial Services rules governing the medical use of marijuana are those that were last amended February 1st, 2018, and that before adopting or amending rules governing the medical use of marijuana, the department must establish a process to include caregivers, registered caregivers, and patients and physicians and certified nurse practitioners with significant knowledge and experience certifying patients under the laws governing the medical use of marijuana in the development of these rules or amendments, and must consult with caregivers, registered caregivers, patients, physicians, and certified nurse practitioners. It requires the department to develop a process to retain any consultant hired to advise on rule changes related to the laws governing the medical use of marijuana, and report on the development of this process no later than September 1st, 2021, and report on any subsequent changes to this process to the Joint Standing Committee of the Legislature having jurisdiction over health and human services matters. It eliminates the requirement that a registered caregiver, a registered dispensary, a marijuana testing facility, or a manufacturing facility complete an annual audit conducted by a third party of their business transactions. And I will note for the committee that even though I had previously noted here an overlap with LD 939, there is no longer the overlap with LD 939 based on the majority report that came out of the committee's last work session. So this is not a overlapping or conflicting provision anymore, at least with 939. And then finally, this bill eliminates the requirement that the department develop and implement a statewide electronic portal through which registered caregivers, registered dispensaries, marijuana testing facilities, and manufacturing facilities may submit certain records to the department. I think that's most of what I have to say on this one, unless there are questions. I just will note for the committee that you know, it sounded like there may be some overlap between reports that come out on this bill or that came out on the last one, and just you know, when eventually reports end up on the floor, you'll want to be conscientious of the extent to which they overlap with each other passing legislation. So.
Thanks, Sam. Anything technical for 1242 that we need to look at?
Let me scroll down to the bottom and see if I forgot anything. I apologize for the. Yeah, I did have a technical note here. The part that requires the department to develop a process to retain any consultant hired. Oh, I'm sorry. Did I talk over somebody?
Nope.
Oh, sorry. I think I just heard some feedback. So anyways, the part of the bill that requires the department to develop a process to retain any consultant hired, I guess it was from reading the bill, I'm not sure it's clear what kind of process or retention must happen. Or like whether, for instance, the consultants, you know, whether they have to hire everyone that's been consulted with, or just, you know, or whether this is just a process for kind of keeping their contact and their availability. So that might be something worth clarifying if you choose.
Okay. Thank you, Sam. Senator Hickman.
Thank you, Mr. Chair. Just for expediency purposes on this Friday afternoon, I make a motion ought to pass as amended with the minority report from LD 1319.
Okay. And
then I will say if we have to clear up any technical issues with that amendment, then it would be for both. So we can probably just talk to Mr. Prower about that.
Okay.
As it's being drafted.
All right, so Senator Hickman has put a motion forward ought to pass as amended. Is there a second?
Second.
Seconded by Representative Sapika. Okay, any further discussion or debate? Okay, seeing none, then Karen, when you're ready, let's call the roll.
Senator Lucchini.
No.
Senator Lucchini, no. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Yay.
Senator Farren, yay. Representative Chiazzo.
No.
Representative Chiazzo, no. Representative McCray.
No.
Representative McCray, no. Representative Tuttle. Representative Tuttle, absent. Representative Riley.
No.
Representative Riley, no. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
No.
Representative Wood, no. Representative Kinney. Representative Kinney, absent. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph. Representative Dolph, absent. 4 voting in favor of the motion, 5 voting opposed to the motion, and 4 members absent, Mr. Chair.
Okay, so the motion not to pass as amendment fails with those present. However, there are 4 absentees that could tip the balance. So I'm wondering if the question is, do we leave the jacket open even though this is the last day we have? Chairman Lucchini.
Thank you. Yeah, Mr. Chair. Yeah, I think we should just let people vote, and then whichever report prevails, prevails. I think give people till Tuesday midday where it's close, and they'll change and go wherever. So I think that's typically what we would do with a large number of absences.
Okay, Representative Corey.
What is the other report? Is it ought not to pass or ought to pass as amended, or what is it?
Chairman Lucchini, I'll let you. I think you're the lead on the prevailing side.
Sure. Yeah. So we'll leave the jacket open. Ought not to pass.
Okay. Anybody on the prevailing side have any objections to ought not to pass? Okay. So the 4 absentees will have until noon Tuesday to cast their vote, and we'll see where the votes end up on which report gets moved.
It's 4:20. I just wanted to say we finished at 4:20.
There is fate, isn't there? There's the fickle finger of fate out there somewhere.
What was it?
Any other questions, Mr. Prower?
Thanks, Representative Calzo. I usually assume this is the case, but I just want to be very clear on these bills, both for 1242 and 1319. Is the committee comfortable with me working closely with the members on each respective report just to make sure that they come out correctly, and that is before I bring it back to committee? Is that?
I'm certainly comfortable with that. If anybody has any objections, let us know. Senator Lucchini?
Sorry, that was for something else.
Okay. Okay, then seeing no objections, absolutely so noted. Sam, please.
Great.
Okay. Thank you. Chairman Lucchini.
Sorry, thank you, Mr. Chair. I just wanted to make sure I forgot or didn't forget before we adjourn on, because I had said to hold 11:55 for potentially reconsidering, and there's Janet. I'm sorry, Janet, I forgot to do it earlier, but I think we're good to just let it go. And if there needs to be changes, we can do it on the floor, I think. So we just need to say that on mic. So sorry to keep you.
No, that's okay. The only other thing was Representative Kinney had a little bit of change to her report, but I'll clear that language with her.
Okay, thank you.
Because I think it's just her report.
So unless I'm mistaken, this is the last sanctioned meeting of this committee, unless barring any special requests or any needs. I take that back. We are coming together for confirmations. So we will be back together again at the beginning of the month for confirmations for the Gambling Control Board, I believe. But I believe, unless Chairman Lucchini or staff has anything else, I think we have concluded our business for the special session.
Are we the last ones working today?
Representative Wood, are we the last ones working today?
Yeah, the energy's still going. We do, I will say, we just got a memo that we'll be doing language reviews by email. So just keep your eye out. I know Representative Kinney had asked. So the POs just sent out, that'll be email. So we'll just keep an eye out on that. So you can see any language reviews. And if there's issues, then we can meet virtually or something, I think.
Okay, Representative McCray.
Thank you, Mr. Chair. Our confirmation, is that on the 11th? Confirmation hearings? Okay. In that case, we won't be seeing Karen. So, right? Will we still be seeing you? Oh, good. Okay, never mind. We'll still
We're trying to extend it. Yeah, we're trying to extend.
You can't get rid of me that easy.
There's no analyst for confirmation hearings, so we won't see Janet or Sam.
Oh, thank you, Janet. And Sam.
Senator Farron.
Hey, in light that Representative Tuttle is not here and everybody wants to go, I wanted to throw out there there'll be a barbecue at. So no, seriously, folks, I hope everyone did great work and appreciate everyone's efforts. And it is a long weekend. I hope everyone has a safe and relaxing time with their family and friends and get involved in the community. And remember that what Memorial Day is all about. And for those folks that have given the ultimate measure, and that's why we get to enjoy this great land and have this weekend. And I appreciate each and every one of you.
Here, here. Representative Wood.
I just wanted to say, as a first-year legislator, this feels to me like I was on the perfect committee. And I know Laura and Morgan and I have talked, but the other legislators, the staff, I just feel like we had the best. So thank you all for helping us.
Thank you, Representative Wood. I think it's been a great experience for all of us, for sure, for sure. Representative McCray.
Thank you, Mr. Chair. I wanted to say thank you to Sam too, because I said it once I was muted. And also, thank you, Senator Farron, because it was good to laugh at the end of a long day with the barbecue comment. So I appreciate that. Much needed.
Yes, indeed, indeed. Senator Hickman.
Yes, thank you, Mr. Chair. I'm always up for a barbecue anywhere. So I think we have to send on the good representative's house because he's not here. So he just has to take us all, right? And also, I believe, well, I don't know how many veterans are on this committee. I don't want to make any assumptions. I know there are at least 2. So have a great Memorial Day and thank y'all for your service. Thankfully, you didn't have to give the ultimate sacrifice. So we are going to certainly recognize those who have come Monday. And Senator Farron, I sent you a message. It's a favor, but I think you'll probably help me again like you have once before. And we'll go from there. Enjoy your day, everyone, and weekend, and all of it.
Senator Hickman, I'm sorry.
Go ahead, Representative Wood. Break protocol now. Come on, we're all done, right?
Senator Hickman, aren't you the closest house to Augusta? Shouldn't that be where the barbecue is?
I'm having a barbecue, so y'all just come on. I mean, I'm always open. I mean, I literally barbecue almost every day in the summer on the weekend. So you don't even have to ask. You just come by and you follow the smoke, and I'll be there.
Well, Representative Corey and I will have to wait till we get out of the pool first. So after that, we might be over. Yeah.
So I'm right down the road, 10 miles. I actually am in my office today. So I am not in my house. I'm in the office on the campus, and doors closed. So when I go out, I put my mask on. But yeah, sure. Come on by.
Well, thanks again, folks. Listen, as a first-time chair, I want to thank everybody for all your hard work and dedication. You definitely made it a very smooth transition for me. It could have been a lot more painful, and I really do appreciate all the hard work everyone's done, especially staff. I mean, people don't see enough what happens behind the scenes to know the incredible work these guys do. And even just up until yesterday with the crazy schedule for bills and people rushing around and asking for amendments and things like that. And with that, I will say double cheeseburger, Representative Tuttle, and a couple of the Redskin dogs, and we should all be there in probably about a half an hour or so. Thank you.
Well, I just got back from my doctor's appointment, and Chris, they said I have a heart.
I'd ask for a second opinion.
There you go, buddy. Yeah. I did, Brad. Yeah. Yeah.
Representative Tuttle, you joined us just in time to say goodbye to everybody. We've completed our work.
Yeah. Good night, Irene, right?
Yeah. Thanks, everybody.
Yeah, thanks, folks. And we'll see you all in person in a couple of weeks. Or next week.
Next week.
Next week.